who is there to be first item?
The first
Item number 2.
Last time you lost direct.
Let me submit.
Item number 2, WPC
My lord, your
2690.
lordship may kindly this item.
Item number 2, sir.
Yes.
Yes,
Yes,
ma'am.
your lordship may kindly see the order dated 4th September
Well,
2020.
today he has, I am the for the petitioner, my lord. As per your lordship's order dated 7/2/2024, immediately they have issued notice and the procedure adopted by the additional Tahsildar is challengeable. And here now, my lord, today I received the copy. So at least 4 weeks time to give the objection, my lord. Because the petitioner number 6, who is looking after the case, yesterday he has gone to Chennai for testing of his heart. He will come after 15 days. So 4 weeks time may be granted, so I will give the objection.
You are there on record or no?
Yes,
You are there on record. Whether you have filed the application.
yes, yes,
You are an advocate on record.
yes, my lord.
You have filed the petition.
Yes, my lord.
So what do you want? Why do you want?
I want, today I received the affidavit to be given by the Tahsildar Jatni, who was directed by your lordship to dispose my case.
I know it was just adjourned. And if I remember correctly,
Now they have produced the record.
so they have passed the order.
Yes, my lord. That is what I beg to submit before your lordship. We have already disposed of that remand case by a reasoned order after hearing the petitioner.
When was that done?
That was done on 12th, Monday.
Well,
Yes, I have served a copy of that order. What I beg to submit, he wants to file objection to that affidavit, which I have filed along with that order. My respectful submission is that if at all he is aggrieved by that order, that is challengeable in appeal. That is a separate, that has to be challenged under section
That will
7 of
also-
the OJLS Act.
Your lordship
Before the appellate.
kindly see, initially the land was resumed by the
And that is a
Tahsildar
subject
Jatni.
matter of the,
Counsel will not go into
Yes.
the merits of this. One, and two, by seeking adjournment, you want to delay it further. It's so your choice. We will adjourn the matter.
I don't want to,
Because you are taking a plea that someone who has to argue, he is in some difficulty. So on the ground of the difficulty of a lawyer, we can adjourn.
no, he is not
No,
saying that. He is saying his client is,
now we have to take instruction because the date which was fixed, my lord, 12th, the petitioner appeared through his advocate, their advocate. And on 12th, the additional Tahsildar giving assurance that after making spot inquiry, I will give further notice for hearing. But clearly violating the statutory provision on the self-same date.
Challenge that order.
Yes.
Yes, my lord.
So you challenge that. Otherwise, unnecessarily, if the matter remains pending, that will surely not benefit you.
So at least because my client is in, so I have to take instruction because only the client, let them to come and I will,
Counsel, the
I understood, my lord, I don't want, because 12 years they have not passed any order.
The court is of the view, when you are before us, the client's face is also before us. All right,
Yeah.
so if you want adjournment only for the sake of adjournment for delaying the matter, it's a.
No, delaying
issue
not.
altogether. But no purpose
My
is this,
intention is not that, my lord, your lordship can see the notice they have also issued.
You are a counsel of some standing at the bar. So if we adjourn the matter for 8 weeks from.
To file objection, my lord.
You'll file objection to this,
Yes, ma'am.
and this court will decide it. This is what you expect.
It is appealable, my lord, but the where large number of cases set aside, by this honorable
order
High
is
Court,
appellable.
since they have already where the factual facts has not taken into consideration and clear violation of the statutory provision.
So then we'll decide it on merits. Come. Not on the merits of the order, on the point of maintainability in view of alternative.
So that is why, my lord, only 4 weeks time may be given. I will take instruction so that I will file a counter to that affidavit and your lordship may pass the order on merit. So I have no objection, madam.
My lord, I have not filed any counter. I have only filed the order copy along with the affidavit
The
of
order copy, your lordship kindly see.
If
Order
at all
copy,
that order
how
suffers from
order
any
copy was
legal
passed,
infirmity.
your lordship, that is, what is that statutory provision I have?
We are acceding to your request. We are acceding to your request and we must observe that what you are doing is, it's a disservice to your client. As requested on behalf of the petitioner. This matter on 4 weeks. From the adjournment is being sought on the ground that an order has been passed by the
Additional Tahsildar Jatni.
additional Tahsildar,
Jatni,
Jatni.
J-A-T-N-I.
Jatni,
Tahsildar Jatni
OP number 4, my lord.
on 12/2/2024.
Yes.
Which he wants to consider. So he however admits that there is a remedy of fee
Under section 7 of the OGLS Act.
under section 7 of so and so. So while adjourning the matter, the court makes it clear that pendency of the present proceedings before this court shall not be available to the petitioner. No, thinking.
All right, your lordship, dispose that, I will file up it. Because your lordship can see the what? The additional, because these observations, they will be on limitation, the appellate authority will reject my appeal.
Then,
That is why your lordship can see on 4th September, the learned counsel was directed to take instruction of whether the case is pending or not.
choice is yours, and you cannot dictate us. We make it clear that the pendency of this proceeding, after passing of the said order dated 12/2024, shall not be a ground available to the petitioner for confirmation of delay in preferring appeal.
Your lordship dispose with that observation, we will file the appeal. If your lordship, because the large number of cases disposed of, your lordship can see the way she has adopted the additional Tahsildar.
Why are you taking us?
Sorry, my lord, sorry,
Please allow us to pass an order
sorry,
this way or that way.
sorry, my lord.
So if we adjourn the matter, it will be with this observation.
No. Because that cannot be fulfilled, the client also.
Then
Withdraw.
Counsel speaking on behalf of the parties. It has been stated at the bar that during the pendency of this application on 12/2/2024, an order has been passed by
Additional Tahsildar.
additional Tahsildar
In resumption, miss case number 37 of 2000,
presumption case number 37 of
2002.
2002,
Yes, ma'am.
which is applicable under section
7 of the OGLS.
7 of OGLS.
7 of. So, that we all matter. Counsel for the petitioner. Give permission to withdraw this application with the liberty to prefer appeal against the said order dated 12/2/2000 statute. And the order dated 12/2/2024. So, this application stands disposed of with liberty as sought for.
I will file within a month, my lord.
That you-
Well, we have not said anything on
And
that.
your lordship can only give you observation because the petitioners have already suffered much more times.
What was the-
That observation, my lord, the appellate authority do well to dispose the appeal as per the statutory
The
provision.
appeal is not
In
filed, my
accordance
lord.
with law.
And
Sir, counsel, you kept the matter pending for.
yes, ma'am.
12 years,
Yes,
madam.
Yes, yes.
Within a
Yes.
stipulated period, my lord.
Yes, ma'am. Your lordship may direct that appeal should be disposed of within a stipulated period.
In accordance with law, after giving opportunity of a hearing, my lord.
Considering the fact that the matter before the additional Tahsildar remained pending for nearly 21 years, which apparently made the petitioner to suffer a lot. It is observed that if the petitioner files his statutory appeal within the stipulated time, then can be expeditiously disposed of.
Further 30 days, my lord.
Just a minute,
Sorry.
let us conclude.
Sorry, my.
And in no case beyond 60 days from the date of passing of, from the date of filing of the appeal.
Yes.
Okay.
Item number 1.
May I please, Your Lordship. Lordship, in this matter, Your Lordships, Mr. Pitambar Acharya, Senior Advocate, is leading me, Your Lordship. He had a personal emergency just now. Lordship, may I pray this matter taken up 2 p.m., my lord? Because the lease is expiring on Tuesday, Lordship. That's the whole difficulty.
Take up this matter tomorrow.
Lordship, may I pray? Because, Lordship, the problem, my lord, deeply obliged, my lord.
Item number 3. Sir. Item number 3.
Lord, beg pardon. Here there is under affidavit, my lord, that we have filed on last Friday, that is 9th February, which is not in your lordship's brief.
You have filed.
Yes, my lord. Your lordship may call it on Monday next.
It is stated by learned counsel appearing on behalf of the petitioner
Sorry.
that a rejoinder affidavit has been filed online.
9th February.
No, but there is a withdrawal memo also.
That is in the second
matter.
Second item.
Second matter.
Second item.
Second item.
Affidavit has been filed. In first case, not. Affidavit has been filed online,
Yes, my lord.
which is not there on record. So stop, list this matter on Monday, along with the said rejoinder affidavit is filed on record.
Interim order to continue till then. That's their interim order,
Interim order shall continue till the next stage.
my lord.
The second item 41843/2023.
The side file hotel memo second matter. So that
Wrong. Second now.
Item number 4.
In this matter, I humbly pray to withdraw the writ petition, my lord.
Withdraw.
Obliged, my lord.
Item number 5.
May I, Lordship?
Yes, sir.
प्रीवियस ऑकेजन अपोजिट पार्टी को बोला गया था वो इंस्ट्रक्शन फाइल करने के लिए 29 डेट को। वो अभी मेरे पास कुछ इंस्ट्रक्शन है नहीं, वो लोग क्या किए हैं या नहीं किए हैं।
My
क्या है आपका प्रॉब्लम?
सर प्रॉब्लम ये है, ये एक डब्ल्यू है, इसमें हम वैकेंट पोस्ट के अगेंस्ट में प्रेयर किया हूँ। तो बहुत सारा केस लॉ दिए हैं और ऑलरेडी डिस्कशन हैव बीन कंप्लीटेड विद इन टू डेटेड ऑफ ऑर्डर।
आपको आपका ग्रीवेंस क्या है? क्या चाहते हैं आप?
हम ये चाहते हैं कि जो हमारा का पर्टिकुलर एडवर्टाइजमेंट हुआ था
कब?
उस 2021, उसमें हम ओवर एज कैंडिडेट थे। तो ओवर एज कैंडिडेट होने के नाते हम कोर्ट आए थे, तो कोर्ट ने बोला था कि आप एग्जाम दीजिए और रिजल्ट परमिशन के हिसाब से निकलेगा। तो कोर्ट में वो लोग रिजल्ट सबमिट किए, तो मैं क्वालिफाइंग मार्क के ऊपर रहा और कट ऑफ के नीचे रहा। तो पोस्ट अभी तक वैकेंट है, वो आरटीआई रूल, तो वो लोग वो नहीं दे रहे हैं महिला।
तो क्यों देंगे? आपसे कुछ लोग ऊपर होंगे मेरिट लिस्ट में।
ओके ओके, मैं प्रीवियस
एक मिनट रुक जाइए।
ओके।
कुछ लोग आपको जैसे 45 मार्क्स आया होगा, किसी को 46 आया होगा, उनका अपॉइंटमेंट हो गया।
नो मिलर, मैं दिया हूँ जो केस लॉ मिलर, उसमें WMA है,
केस लॉ
हालांकि आज में आर्गुमेंट
केस लॉ छोड़िए ना, केस लॉ अगर बोलना होगा तो आपको किसी सीनियर वकील साहब को बोल देंगे आपकी तरफ से बहस करने के लिए, आर्ग्यू करने के लिए। लेकिन कुछ चूंकि आप खुद आए हैं इसलिए केस लॉ छोड़ दीजिए, केस लॉ हम ध्यान में रख लेंगे। दो चीज है आपके खिलाफ, आप ओवर एज हैं, ये तो एडमिटेड है।
नहीं, उस टाइम में ओवर एज थे सर, ये एडमिसिबल है। ओवर एज,
ओवर एज,
अभी ओवर एज है, कोई एजुकेशन अपॉर्चुनिटी है नहीं, मतलब एम्प्लॉयमेंट अपॉर्चुनिटी है।
एक मिनट रुकिए, जब ओवर एज हो गए तो वो एडवर्टीजमेंट के हिसाब से आप डिस्क्वालिफाइड हो गए, है कि नहीं? कोई डिस्क्वालिफाइड कैंडिडेट कैसे हो सकता है?
नहीं, सिमिलर मैटर में ऑर्डर हैज बीन पास।
सिमिलर मैटर में
सिमिलर एडवर्टाइजमेंट ओवर एज मैटर ऑलरेडी डिसाइडेड। There is a lot of things, my lord.
नो क्वेश्चन ऑफ लॉट ऑफ थिंग्स। एक ऐसे समझिए कि आप ओवर एज थे एडवर्टीजमेंट के चलते, फिर भी आप अप्लाई कर दिए।
कोर्ट है पास इंटरिम ऑर्डर एंड सिमिलर बेनिफिट।
एक मिनट सुनिए आप मेरी बात धीरे धीरे, क्योंकि आप हैं इसलिए इतना
मैं हिंदी में बोलता हूँ,
इतना संभल के बोल रहे हैं हम।
ओके।
आप ओवर एज थे फिर भी अप्लाई कर दिया आपने।
हाँ,
अप्लाई तो किया,
अप्लाई किए।
ओवर एज होने के पहले ही कोर्ट में आ गए थे आप?
हाँ, पहले
अप्लाई करने के पहले आ गए थे?
हाँ, अप्लाई करने से पहले।
और आपको कोर्ट ने परमिशन कर दिया कि आप अप्लाई कर सकते हैं?
हाँ, परमिशन दी।
और इसी तरह से सारे कैंडिडेट्स को कर दिया कि अप्लाई
अरे
कर।
नहीं, मैं 5 और 6 कैंडिडेट को हुआ था इंटरव्यू।
तो कम से कम 5 लाख लोग ऐसे होंगे या करोड़ों लोग ऐसे होंगे पूरे कंट्री में जो लोग ओवर एज होंगे, और जो लोग अप्लाई इसलिए नहीं किए होंगे क्योंकि वो एडवर्टीजमेंट के हिसाब से ओवर एज थे। उनकी क्या गलती है?
सर मिलर, उस टाइम हमको परमिशन मिला था और सिमिलर बेनिफिट
मिलने से नहीं होता है।
यस, मैं आज आगू के मूड में।
मेरिट नहीं है आपके केस में।
सर फुल मेरे लास्ट ऑर्डर आप देखिए सर, जो पास हुआ था हमारा, माय नेम लिखा हुआ है, द एप्लीकेंट अपीयर इन पर्सन एंड फाइल एंड एडिशनल
कट ऑफ मार्क्स कितना है? मिनिमम मार्क्स पे जो जिनका अपॉइंटमेंट हुआ वो कितना है?
मिनिमम मार्क इज 72 माय लॉर्ड।
72
तो एंड क्वालिफाइंग मार्क इज 44।
प्लीज देखिए,
सिमिलर केस माय लॉर्ड, सिमिलर केस में बहुत सारे कैंडिडेट को कोर्ट ने परमिशन दी है और सुप्रीम कोर्ट का लॉ भी इन्वॉल्व है उसमें।
सुप्रीम कोर्ट का लॉ इन्वॉल्व होगा
और इनएलिजिबल, दे आर नॉट अकॉर्डिंग टू एडवर्टाइजमेंट।
आपसे सीखेंगे सुप्रीम कोर्ट का लॉ
ना,
लेकिन 71 कट ऑफ मार्क्स है, किसी को 70 था, उसका अपॉइंटमेंट हुआ।
Because our case is different, my lord. We are over age now. Not any opportunity, कोई भी अपॉर्चुनिटी अभी नहीं है। और सिमिलर बेनिफिट में बहुत सारे कैंडिडेट को कोर्ट ने ऑर्डर पास किया है और सुप्रीम कोर्ट लॉ उनको अभी लास्ट मेरे फेवर में भी है माय लॉर्ड।
ठीक है, आप सारा दे दीजिए। यस
My lord, the instruction is ready with me. It's only to be sworn in. And this is our claim. This is our, my lord, I can submit to my lords that the cutoff mark, his score was 47.75, which is much below. That is our case, my lord. His result was published before, was submitted to this honorable court before the honorable single judge. And having seen that, that order was passed. So nothing wrong in that order.
Sir, एक केस में ये हुआ था।
And my lord, the similar order what the petitioner is referring to, they relate to Shiksha Kar, which is altogether a different scheme. Here, appointment to the primary school, high school teacher, contractual high school teacher. It's a different case altogether.
माय लॉर्ड, आप थोड़ा 13/12/2023 का ऑर्डर देख लीजिए। सिमिलर बेनिफिट हिंदी टीचर को वो लोग दिए हैं सिमिलर स्कूल में। उसमें क्या है, वो लोग एडवर्टाइजमेंट में नहीं थे और वो लोग वैकेंट पोस्ट में पोस्ट ले गए और डिवीजन बेंच में भी उनका रीट डिसमिस हुआ। और एक केस में माय लॉर्ड में ऐसा है, वो भी कम मार्क में था वो कैंडिडेट और एलिजिबल ही नहीं था। आप परमिशन देंगे तो मैं रिप्ले फाइल कर दूंगा माय लॉर्ड।
कुछ नहीं करना
माय लॉर्ड, थोड़ा टाइम दीजिए कम से कम प्लीज। केस को मैं प्लीज मैं एक लॉयर अपॉइंट करूंगा नहीं
आपने रिट पिटिशन फाइल किया?
माय लॉर्ड मैं एक लॉयर अपॉइंटमेंट करूंगा वो सबमिट अभी लास्ट ऑर्डर मेरे फेवर में है माय लॉर्ड प्लीज और बहुत सारा एग्जांपल हम दिए हैं और एक डेट दीजिए बस मैं क्लैरिफाई कर दूंगा
सॉरी, आपने रिट पिटिशन फाइल किया?
जी
आर्ग्यू आपने किया था?
आगे हम नहीं किए थे
यहाँ भी आप
किए थे
यहाँ भी आप कर रहे हैं?
मतलब एक ही चांस वन चांस
चांस की कोई बात नहीं है, लॉ
हाँ।
है, कॉन्स्टिट्यूशन है। आप जब यहाँ पे खड़े हैं तो सिर्फ आप नहीं हैं, आपके बराबर के जितने लोग हैं वो सारे लोगों का ध्यान रखना है। ऐसा नहीं होता है कोर्ट प्रोसीडिंग।
सर वन चांस में भी मैं लॉयर दे दूंगा सर एक ही चांस
सॉरी सर,
मैम मिलर एक ही चांस इतना बड़ा
कुछ नहीं, ऐसे नहीं होता। इतना बोला तो
प्लीज मैं बहुत सारा दिया हूँ मैं देखिए डिविजन बेंच
सारा देख लें।
मैं एक रिप्ले एफिडेविट दूंगा वो उसके बाद आप डिसमिस कीजिए क्या कीजिए वो परमिट दीजिए मतलब शुरू से करा रहा हूँ प्लीज
सॉरी
प्लीज माइलर डिसमिस माई कैरियर माई एवरीथिंग वन डेट ओनली
आप पेशेंस समझते हैं?
वन डेट ओनली वो
Patience का-
तीन बार देयर टाइम टेकन वन टाइम प्लीज ग्रांट मी
पेशेंस का मतलब समझते हैं?
समझते हैं आई एम
वो पेशेंस खत्म हो रहा है हमारा।
I am a poor person. I am appointed a lawyer, my lord.
Or-
One date.
यू आर अ लॉयर?
No, I am appointed a lawyer. One date, please give. One date, please.
Sorry.
Please, no, humble submit,
Sorry.
please.
Sorry.
Please, my lord, please one date, please, my lord, please one date. One date I am give lawyer, then whatever you.
Yes, next. Just a minute.
Item number 6.
Oh, orderly order.
Item number 6.
Yes. This is the second consecutive, third consecutive occasion where there is no representation on behalf of the petitioner. This application is accordingly dismissed for default.
Item number 7.
Number 7. I may be excused, the file has been misplaced in the office. And may I pray let it be taken up tomorrow or Monday, my lord? In between, the defect will be removed by the.
As requested on behalf of the petitioner, list this matter on 2 weeks. Stop. In the meanwhile, learned counsel for the petitioner shall be at liberty shall be required to remove the defects pointed out by the stamped reporter and submit an affidavit in support of the pleadings in the writ petition in accordance with requirement under SOS.
Item number 8.
May it please others. But this is a case relating to a repealed Gold Control Act. What has happened? Some gold ornaments were seized from my premises.
In
Myself,
80 when?
it was seized long ago in the year 1975.
75.
What has happened? Simultaneously, a criminal case was also initiated. In the criminal case, I was acquitted, and in the departmental case, they have given an adjudication against me, confiscating the gold. I filed an appeal. The appeal was transferred to the SEGET, which was established subsequently. They found that no opportunity was given and remanded the matter afresh for adjudication within 6 months. This is the underlining.
When was that order passed?
That order was passed 1196.
1196.
96. Within 6 months, they have not disposed of, and they have given me notice to appear is only in the year 2013.
18,
13,
13.
13. After lapse of 18 years. When the notice came, I didn't know what was the notice. So I asked them, I'm just receiving a notice. I'm not able to connect in which case you are giving the notice.
So because
they
there are
gave
so many cases against you.
then they then gave a reply. They gave a reply saying that you have filed an appeal. The appeal was disposed of, and therefore we are giving this notice to please come. My father, this present now I am the son of the original person from whom it was seized. He was suffering from dementia at that time. So with his LTA identified by an advocate, I appeared before the authority and said that please give me some time and I will have to collect the papers and contest. Then the the adjudicating authority said that if you are suffering from dementia, how could you give a wakalatnama to a lawyer, and rejected the wakalatnama. Then I filed a writ petition before the Honorable Court. When the matter was pending, the Central Government Council said that I will take instructions. That was fixed to a date. On that day, the adjudicating authority has again confiscated my goods. Knowing fully well that a writ petition is pending, and that was informed to the adjudicating authority also. Thereafter, the matter came up. I filed an amendment petition. Amendment was allowed.
Yes.
Then amendment was allowed, and thereafter I was asked to file a fresh writ petition, and I have filed this. But my submissions are, this is all the entire problem. Appellate authority has said that within 6 months you have to dispose of. That is one part. The provisions of Section 79 of the Gold Control Act say that if so-called notice is not given within a period of 6 months of the seizure, that will automatically, the goods are to be returned to the person from whom it was seized.
To the person from whom it was seized. This is important.
Correct.
It was seized from you.
Me and my father, both. Seized. And the rider is...
And what was your defense in the criminal case?
Criminal case, that's a... Your Lordship knows, I am a certified goldsmith. Ornaments are there with me.
No, whether a plea was taken on your behalf in the criminal case, that no seizure was made from your possession.
It was from my possession. But
no, what was your plea?
My plea was I am entitled to possess it because I was repairing the goods.
No, in the criminal case.
Yes.
In the criminal case, this was your plea.
Yes.
Are you sure?
Yes. Yes, sir.
Are you sure?
Once your last I'm practically asking me, I will have to check up.
Running page 26, paragraph 3 of the criminal court judgment,
Yes.
where Mr. D. Janardhan Swami
Yes, my father.
was the accused with Doki Sriramulu. Appellant petitioner number 1.
The defense pleads that no bag had been seized from the accused Sriramulu. The excise inspector brought a bag from somewhere of the backside of the houses of the accused. Sriramulu's son.
Yes.
Sriramulu's son. There are
So
licenses.
it was brought from somewhere. This was your defense.
No, defense of my father.
Sir,
There are licensed gold dealers and goldsmiths on.
So in view of the plea which you had taken in the criminal case, the writ application can be dismissed right now. Because of that, you got an acquittal. There is no merit.
But But my point, your lordships are
Difficult. Mr.
pointing me out.
You must have.
Your lordships are cornering me rather. I will find out, I will check up once again. But my I was on the point, section 79 of the act stipulates that within
So you don't have any locus standi to maintain this writ petition because it was your clear case.
Your lordship mean that that was my defense then. In a criminal case, that was my defense. For a moment, let us keep it pending, my lord. I will examine and come back to your lordships. But your lordship kindly.
You will have to satisfy us by tomorrow, not beyond that.
No, definitely, my lord. Definitely, my lord. I will have to.
Tomorrow.
Yes.
Please examine.
Yes, I understand. But now the question will be what is the effect of that defense? What is the effect of that defense in the criminal case? I will definitely examine and come before your lordships.
All right.
But for a moment, your lordships kindly.
The difficulty, all right, we will see. But just be sure that you are not put into further difficulty because of the pleas which you are taking here.
Correct.
All right.
Yes, I understand that. But your lordships will kindly see one just for a moment. At page 112. At page 112, 112, there notice was given to me on 89.
We will not see anything under the provisions of the Custom Act, and it has been rightly pointed out by my brother that your 313. What was your 313 statement?
I will come back to your lordships.
Tomorrow.
And I may be permitted 1 week time for filing of supplementary affidavit.
Supplementary affidavit. 1 week, 3 weeks.
Item number 10. One case, WA, is a similar case, is hearing going on. My respected submission, kindly take this matter in this WA, my lord. My lord, WA 1311, my lord.
No, but this writ petition and WA, they both are analogous.
Analogous means same and similar putting, my lord.
That matter, my lords may remember the recruitment of 2014, challenge in the 2023. In the meantime, in response to that advertisement, appointment has been given. Appointment has been given.
Then why are you?
My lord, this petition in WA on my senior whatever submitted that this case is disposed on 2019. I have challenged this WA. In this case, my lord.
WA you have challenged?
Yes, I have challenged in WA 1311/2022, my lord.
Sorry, this we will see that.
So that
but this writ application has been filed 9 years after the advertisement.
My lord,
challenging the advertisement.
That's why I am praying before your lordship. Can I take this in WA?
Sorry, we will see that. WA we will consider.
Okay.
In the present writ application, the petitioner or petitioners have put to challenge an advertisement dated
4th August 2014, my lord.
4/8/14 or relating to 14 inviting applications for appointment to the post of
Junior engineer civil, my lord.
junior engineer civil. Stop. The writ petition filed 9 years after present writ application filed 9 years after issuance of the advertisement cannot be entertained on the ground of delay and laches, which is accordingly dismissed. Yes,
My lord, I may be permitted to withdraw, my lord.
withdraw.
My lord, liberty may be given to file a better application.
Why?
But I have done certain mistakes, if I'll rectify.
Why better? Better application.
Item 12.
Wait, please, my lords.
Lordship, on the last occasion, your lordship directed to serve me a copy, my lord.
Already served.
No, my lord, I have not received.
If your office is.
No, please, that's.
I have also.
My lord, here is the receipt.
No.
I'm sorry, I'll not embarrass my learned friend,
No.
but we have the receipt. Serving
Who
copy.
was received this? The order was specifically directed to serve me, my lord.
Your office has received, Mr. Mahanti.
Just now I have inquired from my office.
I'm sorry.
List this matter on when?
Any day next week, my lord.
On Monday? On Thursday? Thursday, let a copy of the writ petition be served on Mr. Mohanty,
My lord, PP Mahanti, my lord.
EP Mohanty, learned,
Additional Government Advocate, AGM.
learned, AG. So what is the hierarchy here of the government, this thing?
My lord,
Officer, law officer,
my lord.
a advocate general,
Advocate General, then the government advocate,
government advocate,
then the additional government advocate,
additional government
then the
advocate,
standing council,
standing.
then the additional standing council.
To be frank, my lord, I was a little taken by surprise. We normally serve copies to the office of the learned advocate general, but since my learned friend wants it in person, my lord, I'll.
No, he may be right because the first petition which you file
My lord,
may be served on the office of the advocate general.
my lord.
Now, once the case is allotted to someone and he starts appearing, then copy can be served. Otherwise, it will have to be routed through again the office of the advocate general to reach him.
I was given to understand that defect they will show in the, if we don't serve a copy, normally it will show up on the defect, the matter will never get listed. Anyway, my lord, I don't want to make
writ
much of
petition-
a
just a
small
minute.
issue.
Writ petition has not been served on the.
Yes, writ petition has been served. Entire writ petition with all the annexures have been served.
All right, he appears.
No,
to
my
be
lord, I
right.
have already inquired my office just now, my lord. Officer not received any copy. And he is telling that serving a copy. And last occasion, this
All right,
report, my
we'll
lord.
see, we'll see.
I will
Well-
not make much of a small issue,
All
but
right.
I'll serve
Small
it.
issue. We are raising this
Please.
issue, what small issue?
Yes.
Item number 13.
Item number 13, 1 week time may be given to file the additional document, 1 week time.
Yes, additional affidavit, 1 week. 3 weeks.
Item 14.
Lordship, also in this item, I need to file one supplementary affidavit. Lordship may kindly allow 1 week time.
Item 14.
Lordship, item 14, I need to file one supplementary affidavit. So Lordship may kindly allow 1 week time.
All right.
Item 15.
Lord, I will file supplementary affidavit within a week time.
Your application is otherwise defective.
No, my
And
lord.
otherwise says with defect. What does it mean? What is the meaning of this? Defect.
I'll rectify the defects, man.
What is the defect? What is the nature of defect?
My lord, I'll cure the defect within a week time.
Additional affidavit, remove the defects. Yes,
Obliged, my lord.
3 weeks.
Item number 16.
May I please, Your Lordship? Your Lordship, to 2024 and adjourn this matter, my lord, for the further argument. This is a matter I am challenging the order of the Learned Tribunal, who has dismissed my application only on the ground of limitation. Lord, Learned Tribunal's order, Your Lordship may kindly see, that is at Lord, page 71, annexure 4. Learned Tribunal has held that the applicants, the petitioners.
So your pleadings are complete.
No, my lord, this is the initial stage. At the stage of admission, Your Lordship heard this matter on 7-2, my lord.
Yes.
And annexure 4, that is the impugned order of the Learned Tribunal. Learned Tribunal dismissed my application, holding that the applicants slept over their right for a quite long period, and now they are trying to unsettle the settled position of law. But here, the matter of policy, it is a matter of policy, my lord. Whether, Your Lordship kindly recollect, whether that TBOP and BCR will be treated as promotion or not, that was the issue. And that issue has already been settled in so many cases, and benefits have been granted to the persons.
No, on the last occasion, if I remember correctly, I was not able to understand your submissions and pleadings because of so many abbreviations is used.
Your Lordship, two things Your Lordship put to me. What is LSG? Another, what is HSG?
The two expressions again you use TB or something, which I
am explaining. LSG, that is lower selection grade. That is the one post at postal department, and HSG is the higher selection grade, that is in the postal department, which is a promotional post. So far as TBOP is concerned, TBOP is time-bound one promotion, TBOP, that is, and BCR is biennial cadre review. TBOP that was introduced in 1983, Lord, and by virtue of that scheme, the postal department granted the benefit wherever that promotional avenues are not available or promotional posts are not available. In that situation, postal department on completion of 15 years, they have granted the benefit of TBOP. Simultaneously, so far as BCR is concerned, my lord, that was also given on completion of 25 years, my lord.
What is this year?
BCR, biennial cadre review.
Therefore, either you do something, you improve your pleadings, because if we have to write an order, we cannot do that on the basis of what you are submitting at the bar. So you explain what is BCR, what is this, what is that, and then we may decide according to you if that is policy decision.
If permit, my lord, by way of short written note, I can explain all this.
Not short written note, you will have to do it on affidavit.
Affidavit, my lord,
Do it. That affidavit may contain your written submissions also.
My lord. Your Lordship.
All right.
Your Lordship, kindly give me 2 weeks time, my lord.
2 weeks time is allowed as requested on behalf of the petitioner to file a supplementary affidavit, particularly with reference to the abbreviated terms which have been used in the pleadings. Stop. Yes.
Okay.
Item 17.
Item 17, my lord, the Union of India has filed this writ application. I have to file the supplementary affidavit, my lord, with a memo, because it is in the
supplementary affidavit. 1 week, 3 weeks?
1 week, my lord, within 1 week.
1 week you file, after 3 weeks
My
it will
lord.
come.
By that time, I will file my submission.
File your submission.
Yes.
My learned senior is appearing for the opposite party.
Item number 18.
This matter of had order dated 1st of February directed the petitioner to appear before the authority so that he can sign the forms and amount shall be paid because it's a royalty which has been collected. He appeared, the managing director appeared, and because the amount has not yet been sanctioned by the higher authority, Tahsildar could not pay it. So now he wants 2 weeks time only to make the payment. In the last time,
So you want the higher authority to be punished or Tahsildar?
Because there was a direction to the Tahsildar only. I understand because
we are making it very clear that henceforth there shall be no second contempt application.
Right.
If an order has to be complied with, that must be demonstrated in the first proceeding of contempt itself.
Right.
All right.
Yes.
We can keep the matters pending. We will have patience to see how much time do you take to implement the court's order.
Right.
But we will not dispose of contempt application.
No, I don't say that. I only pray.
Either you comply or face consequences in one proceeding.
Yes.
Not in the second proceeding. Yes.
Only a week need 2 weeks time because he is not the authority. He has already written to the state government. 2 weeks time to make
State is your client.
Yes, ma'am. Yes, ma'am.
You are not representing Tahsildar.
No, because the Tahsildar
you
is only
are representing Chief Secretary.
Right, Lord. The contemnor is only the Tahsildar here. That is the problem, Lord. So he has requested the authorities because they are not the authorities. So
yes. So whosoever is found responsible,
will be
even if he is not a party in the contempt proceeding.
Yes, Lord. That is true, Lord.
On an assurance given on behalf of the opposite parties, the matter is adjourned to 2 weeks for him to report full compliance of this court's order, violation of which has been alleged in the present contempt application. First off, we make it clear that if by the next date this said order of the court is not complied with, this court shall have no option but to proceed in the present contempt matter by initiating a contempt proceeding against the officials responsible for non-compliance of the order. All right. So therefore, it is not Tahsildar.
No, all
officials.
Yes. Yes.
Obliged to yourself.
Item number 19. Item 19.
Says WA.
For the opposite party or petition.
You're for the
Opposite party.
you will have to be this side of.
Appellant has to. Raise the matter.
On behalf of Mr. Kanango Millard, I was appearing in the court below. I'm before Honorable Singh Judge. So Mr. Kanango will appear, my senior. I do it pass over.
Yeah.
After lunch.
As no, not it will come after a week. There is no representation on behalf of the appellant to one.
After Millard, the trial court is proceeding with the matter.
Huh?
In an election dispute, a delay of 18 days. The doctor who was treating the patient, the applicant, he said that I have not examined him. So that is the point, Millard. I pray only 2 passovers. Otherwise, I'll do it. Because he is proceeding, otherwise it will be infructuous. Because my land senior has entered appearance, let him do it.
Pick up tomorrow then.
Tomorrow,
as requested on behalf of the appellant. Appellant.
Item 20.
20, my lord. Challenge the order of the Honorable Single Judge, my lord. That is page 13, page 58, annexure 13, my lord. The Honorable Single Judge dismissed the petition.
Annexure 13.
My lord, page 38,
58, page 58,
Yes,
annex of 13.
yes.
The order starts from page 60, my lord. Only on the ground of, they said it is, no, read petition is not maintainable. Honorable Single Judge says read petition was not maintainable because earlier I have filed a read petition, my lord, on the first round. This Honorable directed to dispose of the repentation in 3 months. The collector, directed collector cut off, my lord. The collector did not respond the order, my lord. I again submitted further repentance to higher authority, to the secretary, because secretary did not dispose of the repentation. Then after waiting for 10 months, I filed another writ petition.
Why? Why did you file a writ petition? You should have filed a contempt petition. Rightly held.
I filed the second writ petition of filed, my lord. The
Second writ petition has rightly been dismissed.
My lord, one I've cited decision, my lord, of this honorable court as a court on the bench of this honorable court, my lord. I filed in my this honorable court has held, my lord. Second petition maintainable. We need not file the in my additional affidavit, my lord. Additional affidavit before the learned single judge, my lord.
And why third writ application will not be maintainable? And then fourth, and then 10th. Every time seeking a direction to dispose of your representation.
Your is right, my lord. Once the single judge is
already file a contempt application, that is more effective.
Because the tendency of this contempt petition going to
contempt petition, what happens?
First contempt, second contempt, you have
after having gone through the impugned order dated 12/9/2023, passed by the learned single judge in WPC number 6991 of 2022, we are satisfied that the petitioner's writ appellant's writ application has been rightly dismissed on the petitioner's second writ application seeking same relief has rightly been dismissed by the said order. First off, the order on the impugned order of the learned single judge does not require any interference by this court. First off, next, learned counsel appearing on behalf of the appellant has argued that the court's earlier order dated
12/9/23, annex page 56, my lord.
No, this is 12/9/23 has yet not been complied with.
No.
Has yet not been implemented, Mr.
No. That I'll take instruction in the meantime.
Has
What has happened?
yet not been implemented. First off, the appellant shall be at liberty to take appropriate course of law raising the grievance of non-compliance of this court's order. All right. The application, this appeal is dismissed with the aforesaid observation.
Item 21.
May I please, your lordship?
Not the contempt petition may be delayed, my lord.
If contempt petition may be delayed.
It's 1 year has to file, my lord. It is 12/9/23, my lord. Order was passed on 12/9/23.
Delayed means what? Barred by limitation.
Barred by limitation.
We will see that. We will manage. There is no limitation under 215 of the Constitution of India.
Yes, ma'am.
We will see.
On this
All right, we will manage. If there is any order passed by the court that has to be implemented, So then let this message go to your department.
Yes, yes, ma'am.
That they should ensure that
That order-
whichever order is there pending for compliance, all the authorities should ensure that
Should be
those
implemented.
orders are compliant.
Compliant.
Even we don't know which matter may take a very serious turn.
My lord.
Item 21.
May I please your lordship. Here, my lord, file this application, file this appeal against the Honorable Single Judge, my lord. That is Annexure 3, my lord.
Yes.
Here, my lord, the Tahsildar issued an encroachment proceeding against the petitioner, my lord.
No, that is different. What is the illegality in the order?
My lord, my humble submission before your lordships, my lord, when the encroachment case is still pending, at that time the Tahsildar threatened the petitioner to vacate the suit land. Thereafter, I filed this writ application before Honorable Single Judge, my lord. The Honorable Single Judge,
Whether this order was passed on 19/1/2024.
my lord. In this case, the Honorable Single
RS7 of the order is in
RS7 is that
page 25.
Yes, we are seeing that. So how much time was granted?
4 weeks.
Have you vacated?
My lord, my humble submission that when the OPL case is still pending, my lord, if I will vacate the suit, admittedly, this is a government land, my lord, admittedly. And I am a landless person and I am staying there, my lord, with my family, my lord. That I have taken plea in my writ appeal as well as in the writ petition, my lord.
And when did
So-
you file this appeal?
My lord, no, there is no, I have not, when the OPL is case still pending,
No, when did you file the writ appeal?
8 to 2024. 8 to 2024, my
Then what can be done?
My lord, then if I will vacate the suit land, my lord, then I will lose the two forums, that is appeal and revision provided under the OPL Act, my lord. So let the Tahsildar should give opportunity to contest the OPL case, my lord. If I will lose, then I will prefer the appeal. Thereafter, I will prefer the revision case. If I will vacate the suit land, my lord, then I will lose the
If you
two
vacate
forum.
the suit land, then how do you say that your appeal will become infructuous?
No, there is no appeal, my lord. No appeal. My lord, Tahsildar initiated a OPL case, encroachment case against the petitioner.
So have you made any application?
My lord, before the Tahsildar, my lord.
Yes.
My lord, I took time for filing the show cause, my lord. I have not filed any show cause before the Tahsildar, my lord. In the meantime, they threatened the petitioner to vacate the suit land.
Sir, did you make any application for settlement of any land?
No, my.
You are occupying a land which you are not authorized to occupy.
My.
Then what is wrong in the order?
My lord, my humble submission that if I am a landless person, my lord, according to the section 7, my lord, the Tahsildar should have considered my show cause that whether I am a landless person or not, my lord.
So do you have any declaration that
No,
you are
my
a
lord.
landless?
I took time, my lord. I took time, my lord, before the Tahsildar.
No, sorry, we are not inclined to do.
My humble submission before your lordships, my lord. Can I pray for some more days time to vacate the suit land, my lord? Some more
No,
days.
you have already crossed it.
My lord, only 4 weeks, my lord. It is not possible because this is I along with my family members are residing on the said suit land, my lord. Only
Yes.
1 month or 2 months, my
Can you
lord.
do that? Huh?
Lordship can extend it to 15 days more.
All right.
1 month.
Huh?
15.
4 weeks.
Yes.
An order dated 19/1/2024 passed in WPC 1094 of 2024 passed by a learned single judge of this court is being assailed in the present writ appeal. So stop. It is next. It is not in dispute that the petitioner is running a shop over a land, unauthorizedly. Stop. This resulted into issuance of notice by the competent authority under what is that act?
OPLE.
Odisha Government,
Odisha
Odisha
Prevention of Land Encroachment
Odisha Prevention of Land Encroachment
Act.
Act 1972. Stop. He approached this court by filing the said writ application, questioning the said notice. So stop. Learned single judge, after having appreciated the pleadings made by the petitioner, disposed of the writ application with a direction to the petitioner to vacate the scheduled land within 4 weeks from the date of order, failing which the authorities shall be at liberty to take coercive, to take appropriate action. So stop. Action in the concerned encroachment case number 41112 of 2023. So stop. 23 in case the wicked the expert to vacate within 4 weeks. So stop. Learned counsel appearing on behalf of the appellant after some argument has submitted that the time allowed by the learned single judge, time allowed in the order dated 19/1/2024 may be extended to further 4 weeks from today, extended by further 4 weeks from today. So stop. In the meanwhile, the petitioner shall vacate the land and take steps for settlement. Settlement.
No
they call it.
settlement. No settlement.
A lot.
No settlement.
No settlement.
No, take steps. This is what I'm saying. And it states by approaching appropriate authority under any scheme available for the scheduled caste landless persons.
Landless person, not scheduled.
Not scheduled,
Not
not scheduled.
Landless persons.
Claiming to be a
Caste.
landless.
Stop. Considering the submission advanced on behalf of the appellant, appellant, this appeal is disposed of with the only modification in the impugned order of the learned single judge that the petitioner shall vacate the scheduled land within is permitted to vacate the scheduled land within 4 weeks from today. So stop. Disposed of हो गया? Appeal stands disposed of. Yes.
Obliged, grateful.
22.
22 same. 22 also same.
Next matters.
22 same.
Same. Grateful.
और change कर दोगे order का.
Item number 23.
Button ballot. 23, I have instructed appearing half matter on behalf of the NHA. I have already entered appearance in the second connected matter. I am requesting my lord to supply copy of the writ petition by enabling take instruction and file the counter the land.
Matters. Matters.
Have you filed affidavit?
No, my lord, I am for the.
Have you filed affidavit in accordance with the requirement?
Affidavit, no matter.
File it.
I'll file in between.
Learned counsel for the petitioner seeks liberty to file a supplementary, an additional affidavit. You call additional affidavit. So I have the habit of saying supplementary affidavit because of my past practice. Additional affidavit in support of the pleadings on record. Pleadings in the writ petition. How many pleadings are there? There is only one writ petition or something else. Pleadings in the writ petition in accordance with so and so within 1 week. So stop. He also submits that he shall be serving a requisite number of copies of the writ application on learned counsel representing National Highway Authority of India.
Union of UP number 1 only.
My lord, my lord, appeal to OP number 1.
I'm for the OP number 1.
All right.
By day
tomorrow.
matters. By tomorrow.
By Monday. By Monday. So stop. And then Deputy Solicitor General for India is present for OP number 1. So stop. List this matter on 3 weeks. You want it earlier?
Equal at SIP permits, my lord. If my lord pleases, my lord.
He may have to file reply. Hold it. The court expects that in the meanwhile, the opposite parties shall file their pleadings. All right, let it come after 2 weeks. 2 weeks.
Item 24. Twenty-four, my lord.
File a supplementary affidavit to the effect. I want to file a supplementary affidavit, my lord. It is 7 days time at least, my lord. 21st 26.
1 week, 3 weeks, additional affidavit.
My lord.
So I have corrected myself. Instead of supplementary,
Yeah, additional affidavit. My lord.
all right. Additional
Within 1 week. My lord.
1 week. So and so on.
And
Yes.
in second item, interim order is there.
Second item,
My lord.
or
That interim order to continue, my lord, till then.
in the
But I
interim
have
order.
an objection on that interim order, Madam. Well, kindly glance that order of the which is annex in annex of 14. This is the order of the commissioner, Madam. Where the commissioner is directed
But no
to
counter-
redemarcate.
Just a minute.
Madam.
There is an interim order passed in his favor.
Madam.
So you want this court to recall that?
Madam.
Have you filed any application?
No, Madam, I have not.
Do it.
Madam, I'll file it.
Do it. Otherwise, we may presume that you don't have any problem with that.
I'll
interim
file
order.
counter.
Item 25.
My lords, item 25. This is the matter, my lords, GST first appeal order is under challenge because there is no tribunal.
Yes. So, Mr. Mishra was about to.
Your Lordship,
Yes.
Your Lordship, what my Lord and Senior submits, Your Lordship may kindly turn to page 12, the prayer. Your Lordship is right by annexing the first appeal order, and he is ultimately challenged the first appeal order, but his prayer is to challenge the assessment order.
Okay.
So he has to rectify his prayer, Your Lordship.
No, but finally the matter has to go before whom?
Tribunal.
Tribunal. So we will follow that order.
Your Lordship, but first he has to amend his prayer, Your Lordship. Your Lordship may kindly look into the prayer. Because in the prayer, he has not challenged the first appeal order.
We will not go into that. Every aspect shall be considered by the tribunal.
That's right. But the impugned order here is the first appeal order. And in his prayer, he has not challenged to quash the first appeal order.
So we shall not refer to whatever has been mentioned in the
Your
petition.
As Your Lordship, please.
All right. But whether he has given his notes, he wanted some modification. In fact, what happened?
My lords,
Those matters have been
112.8. My lords, 112.8 says on payment of additional 20%, the balance amount will be stayed. That should be followed, my lord, since there is
We
no.
will follow that.
My lord.
But some suggestion was being made. In those suggestions.
My lords, earlier the practice was it was admitted and interim order was passed. Your lordship is suggesting to dispose of.
But in the order which has been passed by the High Court.
My lord.
He says that there are some issues with that order. And that should, the order requires further improvement.
Your Lordship, those matters are tomorrow. Those matters have been fixed on tomorrow, Your Lordship. Your Lordship.
Let it come
two
tomorrow.
matters be fixed on tomorrow. Your Lordship, along with yesterday's, Your Lordship, I'm just keeping Your Lordship. Your Lordship.
Item 26.
26, my lords, tomorrow the same issue is here, involved here, my lords. 26.
Your Lordship.
Item now 27.
May I please, my lords, 27. Your lordship kindly see page 92, my lords.
Your Lordship, along with this 27, item 65 may be taken up.
Yes, yes. Same issue.
Same issue.
My lords, what happened here, my lords? State agencies.
So we will take up this matter.
No, Your Lordship.
Yes, ma'am.
I'm for the Central Revenue Department. But so far as the next item is concerned, that is now influxus because he has challenged the summons. And after summons, this so-called notice has been issued.
So we'll take up 27 only.
Yes, Your Lordship, can I take up 27? Because that is influxus, because basing on the summon and this so-called notice has been issued. So,
So Lordship may take up this matter. Your Lordship.
What about 65?
My lords, 65, my lords, if this is allowed.
No, that has become influxus.
No, my lords, how? That is not influxus. So I'll argue that, my lords. So that will be called, my lords.
If he says that it has not become
Yeah.
influxus,
yes, then
Your Lordship, let him
are
have.
we not required to hear both the?
definite, sir, definite. Absolutely correct. Can I take up both the
So
matter?
we will take up 27 with 65.
Yes.
Yes.
All right. 27 with 65. Can we take up the matter tomorrow?
My lords, tomorrow I have day, Monday, your lordship.
Good.
Item number 28.
May I please, Lordship? Here the petitioner is a successful bidder. And his bid is valid up to 2006, Lordship. Because the bid is for 3 years. So for the reasons, Lordship, state I come to Lordship. Page 43 of the terms of contract. 43, Lordship, kindly, page 43. Lordship, section 4, Lordship, terms and conditions, Lordship, page 40.
Clause
Lordship, clause was
43.
43, Lordship, page 43.
Yes.
Lordship, period of engagement.
Yes.
The engagement shall be period of 3 years from the date of actual operation, beginning of service or signing of contract, whichever is later. Then let's say B is also there. The contract may be extended for another, for maximum of another 2 years, 1 year at a time, in existence of conditions with mutual consent in both the parties in performance is found to be satisfactory as per assessment. Then Lordship State come to
No, this tender is about what?
Lordship, there's a cleaning up this, Lordship, Lordship, kindly see, this is a scheme adopted by the state government in the name of Nirmal scheme, Lordship, cleanliness Nirmal scheme, to provide various free ancillary services of people at all state-run hospitals. And the scheme is made to quality health services, Lordship.
Now come to 4.
Lordship. Then Lordship, this is my 3 years. Then Lordship, kindly come to
So when were
Page-
you engaged?
Lordship, kindly come to page 82.
When were you engaged?
Lordship, on 14/2/2023, they issued me work order. 2/2023, they issued me work order, Lordship, award the contract in favor of me at page 82. And Lordship, page 85, Lordship, on 14/2/2023, I executed agreement.
When?
14/2/2023. Now, Lordship, kindly come to straight away. When this contract is in operation, Annexer 5, Lordship, kindly come to 29/12/2023. Now they have issued a notice of termination. Lordship, kindly see the contents of the termination, Annexer 5, page 93.
Yes.
Lordship, subject Lordship, termination of MOU/contract under Nirmal with effect from 1st April 2024. I am reading the statement on the contents, Lordship. Sir, this is to inform that the MOU/contract for housekeeping and cleanliness services under Nirmal is valid up to 28th February 2026. With reference to the letter cited above, the scope of services and other terms and conditions have been modified second phase EFCF Nirmal so as to improve the quality of services and selection of appropriate agency shall be done through fresh tender process. As the general condition the contract,
Is there any dispute resolvable?
No, Lordship, because Lordship, what they have done during period of contract, Lordship, they have come up amending the enter the guidelines, Lordship, they are not coming up with a new tender. This is my humble submission. This is absolute with their authority because only scope remains with them as for clause for 8 as per own agreement. Lordship, kindly come to close. Lordship, that page, running page. Running page 48, Lordship. Because I am operating, Lordship.
Lordship, one thing, my lord. Lordship, kindly see page 46 for a moment. Page 46 of the DTCN, my lord. Lordship, kindly see page 48. There is a clause, my lord, CC. The contract can be terminated at any point of any time prior to its completion by either party with 30 days of the notice period. Then,
Did you give him this?
yes, my lord. Lordship, kindly see the.
Then
So you are terminating all the contracts. All the contracts, you must have, all the agreements you must have been terminating.
My lord, to give the
Because
better,
of your new policy.
my lord, to give the better facilities of the hospital, my lord. That's why we are giving a 30 days notice, my lord, pursuant to clause CC of the DTCN, my lord, page 48. 30 days given notice were given at page, my lord, annexure. Lordship, kindly page 93. That's we have given the 30 days notice, my lord. Page 93 for a moment, my lord. My lord.
So this situation must be there throughout the state of.
Lordship.
Throughout the statement, my lord.
But Lordship,
My lord,
no,
most of the
they have not done that, Lordship. They have
Most
not
of the
done.
cases, my lord.
Yeah, Lordship, kindly say, I am
to
just
four
relying
cases,
judgment of annul apex on Lordship.
My lord, most of the cases.
We'll see.
My lord.
But
2 weeks.
My lord. 3 weeks, my lord. 3 weeks.
Time and about for the state to file, opposite parties to file, counter affidavit. But counsel for the petition of that. Meanwhile, file and additional affidavit.
already filed, Lordship.
So we will rise for white.
Only Lordship, I am operating, Lordship. That put, I am operating, Lordship. I am status quo, Lordship. Otherwise, let them play mischief, Lordship. Lordship. But Lordship, that protection, Lordship.
If they stop, then you can make a mistake.
Lordship, grateful, Lordship. Lordship, sorry to make a mention, Lordship. In my matter, they have come up with a fresh advertisement. That has to be stalled, Lordship. In my case, 28.
The. To file counter affidavit. To this matter on. Date result. To be taken up. As the. Within first 5 cases. Oh, stop. The state respondents, these are. Have you brought on record the?
Annex 7, Lordship. Annex 7.
When was that issue?
Lordship, that.
But
That is on Lordship 2/2/2024, and they fixed the cut-off date, Lordship 26/2/2024.
26/2.
Lordship, cut-off date, Lordship. For last date of participation of tender, Lordship.
Participation.
Lordship.
Then it will take time.
Immediate, Lordship, 26 next week, Lordship.
26, yes. So 26.
Lordship, granted 3 weeks time, Lordship.
26 is the last submission, date of the last submission of bid mail.
No final decision, Lordship, in tender, Lordship.
You can also apply.
Lordship, I am continuing, Lordship, two judgments of Honorable Apex. This judgment is with me, Lordship, and it is promissory estoppel, Lordship. They have given, I have invested crores of rupees, Lordship, in that contract, Lordship. I need positive order.
You will not participate.
If I participate, they will come. Once you participate, you have no right to continue, Lordship.
Don't participate. If you are not willing to participate, then don't participate.
But they will say.
The party shall maintain its status quo.
Let's
stop. The state shall at liberty. The state shall be at liberty to approach this court for modification of today's interim order.
Lordship, grateful, Lordship.
In case of necessity.
Lordship, grateful.
Item 29.
May I please? Lord, this case is, I challenge the annexure 1. Starts from page 16. And this issue has been already settled by this honorable court by the order which has been referred in the said notice. Kindly see page 16.
We are there.
Sorry.
We are there at page 16.
Yes. This letter has been issued referring the memo number, Lordship, kindly see third line of the letter. So and so dated 19/11/2019 and memo number so and so dated 7/6/2021. This issue, Lord, has been decided by this honorable court and stated that it cannot be retrospectively taken into consideration, and state has challenged before the Supreme Court, and Supreme Court has approved this order of the Honorable High Court. I have enclosed in the Supreme Court judgment, Lordship, see turning page 283.
Oh, what is your stand?
Lordship may dispose of, my lord, his case may be considered taken into consideration of
This,
this judgment.
earlier this order was passed. In my case also.
Because that
Taking
is
into
upheld by the
consideration-
Honorable Apex Court, my lord, Lordship may dispose of this petition.
It should be quashed, my lord, because
No, it cannot be quashed.
yes,
It
this
can be quashed only after giving him an opportunity, or it can be disposed of.
not in terms of this notification which was referred in this or later. This notification is quashed by the honorable court, taking into account that cannot be retrospectively effect not. And state has challenged the Supreme Court.
Which notification has been
This
quashed?
notification, my lord, kindly see, my lord, I have enclosed 271, page 271 to 282.
Office memorandum 7/6/2020.
Just a minute. That notification finds mention in the impugned order.
Yes, imbue, yes. That is what my assumption. Lordship, see the page, next page 16.
Yes. OM number and OM number so and so.
Yes, dated
These
91.
notifications,
Yes.
notifications.
These
have been
notifications,
passed.
yes,
Second, 7/6/2021.
both.
Both.
Then if this is admitted, then we can.
Yes, Your Lordship, that is what my submission. And my lord, by filing the affidavit,
Fine, please do it. An affidavit has been filed today in the court on behalf of the petitioner to support the statements made in the writ petition in accordance with the requirement under so and so. Stop. A communication dated 21/2024 issued by the superintending engineer Devgarh bracketed R&B division addressed to the petitioner
yes, Your Lordship.
is under challenge in the present writ application relating to price adjustment bill for the work construction of ladies hostels, ladies hostel bracketed GF Gens, hostel bracketed GF, ETC, as per notifications, that is OM number 07556900242019-15847/W dated 19/11/2019 and OM number 07556900242019-8189/W dated 6/7/2021 issued by the Works Department, Orissa. Full stop. It is not in dispute that the aforesaid OMs have been interfered with by this court by a judgment by a coordinate bench interfered with by a coordinate bench of this court by its decision dated 8/9/2023 passed in WPC number 30191 of 2021 to the extent the same were found to be having a retrospective effect. So stop. Assailing the said impugned order, learned counsel appearing on behalf of the petitioner has submitted that since that the very foundation of issuance of the impugned notice has been interfered with by this court, the impugned notice cannot be allowed to survive.
Retrospective cannot be retrospective effect cannot be made because the judgment says will not para 29. It cannot be retrospectively taken into consideration.
See, whatever this notice is based on this.
Yes, Your Lordship.
This has been set aside.
Yes.
To the extent it has the retrospective effect.
Yes, it cannot be retrospective. It can be prospective.
Right. survive and can be survive. Cannot be allowed to survive. Stop. Next. This is not in dispute. Learned counsel, learned AGA, representing the state of Odisha, has not disputed the fact that the said OMs have been interfered with by this court to the aforesaid extent. Stop. The division bench decision of the aforesaid division bench decision of this court, on challenge before the Supreme Court has not been interfered with the dismissal of SLP. What is
At page 283, my lord. Annexure 4. 283, my lord.
the dismissal of SLP bracketed C number 2809/2023. By an order dated 2/1/2024. Stop. Next. In such view of the matter, the impugned order dated so and so annexure 1 is set aside with an observation that the said OMs can be given prospective effect only, and the respondents shall be required to proceed accordingly. So, the application is allowed to this application is allowed, writ petition is allowed in the terms as noted above.
Much obliged. Item number 30.
My lordship, there is a similar matter which has been kept for tomorrow. May this issue be also taken up tomorrow,
Why?
because arising out of same issue.
Which issue?
Um,
All right. Tomorrow, that's sales tax,
Your Lordship.
GST.
yes.
Your Lordship, I'm sorry,
GST.
copy has not been solved. Copy has not been solved.
Served upon.
I think that is against that first appeal 1020 matter. I think he's submitting.
Same matter.
Your Lordship, tomorrow, those matters have been fixed
All
on
right.
tomorrow.
Have-
So, but in the meantime, she may solve a copy to me.
Have you filed an affidavit? Do it. Let an additional affidavit be filed on behalf of the petitioner by tomorrow. You can do it
Yes.
by tomorrow in accordance with so and so. List this writ petition along with
I've given the number. I've
Give the
given the
number.
number. Copy you to phone, copy you to phone.
Item 31.
My lords, may I please, my lords? Lords, the petitioner is a works contractor. He is executing certain works in the district of Cuttack. My lords, this honorable court in WPC number.
What is your grievance?
My lord, grievance is I don't have sand. Across this district, there is no sand quarry. Because I'm executing the work from Khannagar to the bridge, to the highway. There is no sand, my lords. The sand quarries has been suspended pursuant to orders of this honorable court. I am not there, my lords. I'm not challenged. I'm not anywhere challenged by that, challenging those orders. But what my request is, as per the section 34 and 35, rule 34 and 35 of the Women's Rule 2016, I can be provided with sand quarries. I have made a representation to the collector. That is at Annexure 3. And I have also represented my employer that this is my representation, Mr. Annexure 4. Annexure 3 can be considered. He can give me a sand quarry and I can execute the works. My works are being delayed. because of the non-habitable.
Querying has been stopped, then how can he allow your representation?
You can.
No, my lord, that writ petition was disposed of, my lord. We have been allowed to operate, my lord. Lordship, we take up this matter along with WPC 6375/2023, my lord. That writ petition was disposed of on 6/2/2024. And this writ petition was filed on 7/2.
No, that writ petition is pending. I have checked last.
No, not pending. That was disposed of. On
Then, my lords,
6/2/2004, my lord.
My lords, in that case, Annexure 3, my lords, I have prayed to the collector. I have a right to get a sand query to execute the work. Now, my lords, Rule 34 of the OMMC rule. It says that an application for grant of query permit shall be made to the competent authority in Form Q and shall be accompanied by. It provides various things that are accompanied by, but in the proviso, it states that provided that no query permit shall be granted to anybody other than the state agencies or project proponents for public purposes.
Sir, that is the question is.
Yes, my lords.
Do you have any right?
Yes, my lords.
Or do they have any obligation to grant you permission?
This provision is provided.
This provision is enabling provision.
Yes, yes.
It is not that there is any requirement that they must.
Yes. My lords, I am executing works contract. Public purpose
works contract. If under the terms of that contract there is some clause that the government shall be required to give you lead, then the matter is different.
No, there is no clause.
No, it says that I should get all applicable permits from the government.
Yes.
So applicable permits, my representation, if the collector considers and says that, okay, whether he rejects it or he says that, okay, I am granting you a simple. So.
The other petition?
WPC number 6375 of 2023.
What is that? That was filed by him.
No, my lord. That was a PIL, my lord. And that was disposed on 6/2/2024. Order is, my lord, we have allowed to operate this sand quarry, my lord. We have allowed to operate, my lord, by way of the different mechanism, my lord. So that's why that petition was disposed of. One thing, my lord. And second thing, my lord, he is a contractor. He has submitted his bid taking into consideration of the estimate amount. And he has requested and there is no permit, because the permit is in temporary nature. And he has no right. Rule 35 says
he cannot claim any right.
My lord.
No.
He cannot claim any right. If he wants to go anywhere for whatever, if he wants diamond lying somewhere, he can apply for that.
My lord. And my lord, even if he has quoted his price, taking into availability of rate and the prevailing price.
No, that cannot be done.
Lords,
now simply to delay that work, my lord.
Lords, Lords, he is correct. I do not have a right. But what I'm asking for is not something that I want
for the first time we are listening from a counsel for the petitioner saying that government counsel is correct.
Yes, he's correct. He's saying that I don't have a right. I agree. Lords, I am asking that I may be granted a query just because I'm executing public works under Section 35.
There is no such requirement.
Yes.
You may invoke, you may not invoke that provision. Anyone can, your friend can apply for that. And you can have some understanding with your friend that he will be supplying you.
There can be denial by them. There is no denial. The collector has received a representation. He does not deny it. He's kept it pending. That may be decided, Millards. That Annexure 3, if he decides otherwise, that no, I cannot grant you query, you get your own. That a collector can say it. He's keeping quiet over it, Millards, sitting over it.
The petitioner claims that the work of improvement to Cuttack Ring Road,
yes,
number 6 lane standard from change 19/60 kilometers to 21/700 600 700. kilometer bracketed Khanna Nagar to Link Road has been awarded to you,
Yes, I am awarded to.
has been awarded to him. An agreement to this said effect has been entered into on 27/6/2023. Stop. For execution of this said work, there is requirement of sand. Stop. He submits that in that view of the matter, he should have been given permission.
Permit.
Permit. He should have been issued permit by the state government for sand quarrying under the provisions of section 34.
34 and 35 of OMC rules.
34.
Rule
35,
34 and 35.
34 and 35.
Section 34 and 35 of the Odisha Minor Mineral Concession Rules 2016. Stop. Next. We do not find any merit in the plea which has been taken in the writ petition, nor the submissions which have been advanced on behalf of the petitioner with reference to the provisions under the said rules. So stop. There is no right, no vested right in the petitioner, nor any obligation on the estate for grant of such permit, in the circumstance as detailed in the writ petition. Stop. We do not find any merit in the present writ application, which is accordingly dismissed.
Lords, only one thing, Lords. I have applied for a permit. That may be considered by the collector. That is my only request.
Learned counsel for the petitioner has submitted that the petitioner has applied for grant of permit under the rules. Stop. He shall be at liberty to pursue his matter before the competent authority.
Yes. Item number 32.
Lordships have been pleased to dispose of similar matters, granting 6 weeks time, Lords. That 28 capital A application under the Land Acquisition Act 1894 for reference, Lordship, your Lordship may call it also 6 weeks after, so that in the meantime we can comply, your Lordship.
Do it.
No.
6 weeks time is allowed for the opposite parties, opposite contemners, or the contemners to fully comply with the court's order. That is court's order. Stop. The opposite parties, the court makes it clear that the court that it shall take a serious note of the matter if in the meanwhile the court's order is not fully complied with. Well, that's it.
Item 33.
In fact, in one of the cases, I'll punish them. No. Again assuring.
Yes, no, yes. I've seen that all your Lordship's orders are complied with. Yes.
In one of the cases, if the situation demands,
Yes.
then we will take the extreme action
Look,
of punishment.
the message are already gone. Yes.
Very good. Then please do it. In fact, what we can do, we can fix a date for disposal of contempt applications. So you suggest us a date.
My day, my lord, particular day.
One day, one date.
Either Thursday or.
No. My lord, 2 months after this, the cases, let the cases be listed, and you will be telling the court that yes, every order has been complied with.
That I will. I will do that, bro.
All right.
Do that. Whichever is complied, I will make a mention
Yes.
so that also you can get
Yes.
better listed and dispose of.
Yes.
Yes.
So this can be done.
Yes, bro.
Otherwise, you don't know which case.
No, I will do that, Lord. I'll be happy to do that also, Lord, getting disposal of all this. But item number 32 to 35, those Lords, Municipal Corporation, Bhubaneswar Municipal Corporation, wherein the Lordship passed an order directing the Municipal Corporation to have a standing panel council to receive. My friend was also there, Lord. He was also party to that proceeding.
I had received as per your lordship's direction in other 4 cases. I can receive notice, your lordship may grant me 4 weeks time to file.
No, but so whether something has been done in the meanwhile.
No, I have already suggested and they are appointing 2 lawyers to receive copy in the matter of division bench matters and one in civil bench.
It's a very simple thing. Just for the
That we
purpose
will-
of receiving
That
the.
we will do it within a week.
All right. That what I suggest.
To 35, all at second contempt. All at second.
Last. Last is the case. All right, some copies.
To me,
For Mr.
D.K. Mohanty,
Mohanty.
BMC Council. Council for BMC, Bhubaneswar.
Municipal Corporation in of the matter. By Monday. Yes. By Monday. So, list this matter on 6 weeks. 6 weeks.
6 weeks.
6 weeks. So, it is expected that meanwhile, the contenders said the report. It is expected that by the next day, then on the next day, the contenders have reported full compliance of.
Item 36.
36, your lordship, kindly grant 1 week time to remove the defects, my lords. Yes, 1 day delay. I will file appropriate petition. Yes, lords. Yes.
36.
Yes, grateful, lords.
So, I will.
Grateful, lords.
37.
37, my lord, there is a delay of 53 days in preferring the writ appeal.
We saw the other side.
My lord, notice has not gone yet. Obliged.
Let's. Let's 1 week.
Within 1 week, ma'am, on limitation.
Item 38.
38, my lord, kindly taken up next week, my lord. I pray for an adjournment, my lord, to next week. My lord.
What is you? You, why you DA?
Huh? So this matter is pending for the last, for you. Good, yes. You are again-
Only next week, my lord.
Huh?
Only next week. I prefer only next week, my lord. Any date next week, my lord.
Who is the other side? Who is the other side?
Noting is that other is not appear, my lord. Noting is there, my lord. Memo of appearance of Mr. J. Manti on behalf of appeal number 2 not received. So other side not appear, my lord. Other side not appear till yet.
Who is the other side?
My lord, workman. One from Mr. J. Manti, my lord.
Workman is for the other side.
Yes, my lord.
What will be your warrant?
Word is at page 21, my lord. For that. To pay full back wages with other service benefits from the date of retrenchment till date of superannuation.
Have you calculated the back?
Yes, my lord, I have calculated and submit one memo at flag E, my lord.
What is the total amount?
Total amount. Total amount 2,60,000. I have paid 1,36,000. Rest amount to be paid, my lord.
Pay that.
I will pay. Other side did not appear, so let them appear. I will pay in the meantime.
That's it. That's all.
Order is there, my lord, and noting is also there.
Huh?
An order is
How much
there.
money have you spent on litigation? Cannot pay this poor employee.
I will pay, my lord.
You have money and therefore you have luxury to.
This newspaper does not exist till that, my lord. The Prajatantra, one of the newspaper of the Odisha.
Whether the person is surviving or not. Further, state rent.
My lord.
So what is the amount of the tribunal? Don't press it. Otherwise, you may have to pay more than what has been awarded by the tribunal. So the
Let it,
option is yours.
my lord, let it be common next week. I will.
Huh? And what? What way? It's a night. What way? Still tribunal will go and sure. You get 9,000. And referring to the section of the Industrial Dispute Act 1947. And the challenge. The challenge. The present application filed under Article 226 of the Constitution of India. The opposite party in whose favor the award has been, the petitioner is the employer, and the opposite party, a workman, who was a working journalist. So,
the tribunal, after having considered all the issues that reached the conclusion that the opposite party was entitled to get the relief of reinstatement with back wages and other service benefits, subject to the liberty to the employer to initiate disciplinary proceedings against him. So far, noticing the fact that the opposite party had attained the age of superannuation, the tribunal, instead of the deemed it proper to direct, deemed it proper to hold that he would be entitled to full benefit with other service benefits from the date of retrenchment till the date of superannuation.
If I can intervene, subject to it, my lord's permit, my lord. This can be finally disposed of by my lords right now, my lord. Pursuant to earlier orders, we have filed an affidavit. Your lordship sees, as your lordship was rightly observing, but I just came rushing. That's why I'm little.
Rightly observing, did you
Rightly,
listen to the observation?
No, I was all throughout standing here while your lordship was dictating.
What?
Lord,
You observed so many things. About the cost of litigation.
my lords, let me just make the position clear. Lord, management is Prajatantra management. Only to the extent challenges the direction with regard to full back wages. To that extent only this litigation is confined to right now before my lords. If at all the tribunal is directing reinstatement, but in view of his he has said that he is entitled to reinstatement with full back wages. That's what he has said. That the tribunal has said. But what I'm trying to tell you, lordship, that
The tribunal says that he was entitled to reinstate.
correct, I'm grateful.
But it did not issue any.
In view of the superannuation age, the reinstatement order cannot be passed, but then full back wages has been allowed. Lord, very limited point. Lordship will kindly see this employee was transferred. On his representation, relief order was also given to him. He did not join there. It's a indiscipline. Merely on the ground that you have not dismissed him from services, the tribunal has concluded that he has a case and he is considered to be reinstated. He is a case of retrenchment and consequently granted entire benefit, irrespective of the fact that the employee has not contributed anything for this organization during that period for which he has never worked. So the Supreme Court says at best 50% back wages should be allowed. But, so if your lordship permits me, I can give that Supreme Court judgment also, which says that in these cases where the employee has not contributed to the management anything during the period for which he is entitled to reinstatement, 50% back wages is always proportionate.
In our order that this will not be a precedent. This will not be treated to a precedent, but considering the meager amount, 1 lakh or something.
But I have made a calculation. Plug in. Lord, we'll pay the whatever amount falls. Lord, whatever amount falls as per this calculation, we'll pay it to the employee, Lord, as per taking the 50% of the backlines. That your Lordship may clarify, dispose of the matter, within a stipulated period, we'll pay it.
We don't want to.
As your Lordship is proposing to pay the entire
Whatever has been awarded.
full back wages. That, in my humble opinion, my Lord, Lord, I'll be citing a judgment, kindly consider this, Lord. Whatever. Para 20, Lord. Lord, it starts from para 12. Para 11, 15, 17, and 19. Lord, for your Lordship, there is also.
There is no dispute over that position of law.
Yes, Lord, that's what I'm just saying.
There are two things. If someone claims back wages, he has also to satisfy the employer that he was not gainfully employed otherwise.
But two things, my Lord. One, he was not gainfully employed. Another is he has to contribute during the speech.
Anything, therefore, he will be entitled to only.
That's what Honorable Supreme Court. That's what Honorable Supreme Court says.
We are having been conscious of this position.
Correct, my Lord.
We don't intend to interfere with the order because of the amount and petty nature of the dispute.
May I just request your Lordship one more thing?
And therefore, we are not deciding the law. We are not entering into that.
Lord, management at Pradatantra, my lords may not be aware of. It's a very bad shape of its financial condition. Bad shape. It's almost closed. Even 100 publications a day is not possible. It's just nearby the Honorable High Court, my Lord. Its factual position is the management virtually is due now. And the correct position is not. We have been proceeding.
We could have considered the submission, this submission, had your junior been addressing this law. But
then I take my seat, my Lord. I take my seat, my Lord. Let my friend say.
No, you cannot.
I take Lord, I take a back seat, my Lord. I take a back seat.
Management has chosen to engage a senior counsel to.
Let me again make it candidly clear, my Lord. Let me again make it candidly clear, my Lord. What should I say?
Don't make that clear.
Yes, my Lord. I should not make it that clear, my Lord. I should not make it that clear, my Lord. Let me also not disclose that, my Lord. But one just small request, my Lord. It's a case indisciplined act of an employee, my Lord. He is not obeying the management.
See the circumstance where even no one is representing him.
But I'll tell why he is not being represented. He is gainfully employed in another newspaper. That's what we have been saying it.
All right. If you have stated anywhere.
We have stated, but tribunal has not considered that.
No. Whether in the writ petition you have.
Yes. Stated. Before the tribunal also such a stand was taken by way of an additional affidavit. Kindly see, madam. Such a stand was taken in Sambad. He was very much working in Sambad newspaper.
That aspect has been taken note of.
That the way it has been rejected, kindly see, my Lord, they say that management has not given any evidence to prove that. But he is working in a different newspaper, and it can't be proved, my Lord. We can't get any paper for. No. That newspaper agency are not disclosing any information. He is some other newspaper. Kindly appreciate the constraint, my Lord. They are not.
We cannot advise you, Mr. Senior Counsel, how to prove a fact.
But they are not subject to RTI, private organization. Lord, kindly consider this. Keeping all this in view, I request me not to fix it at 50% so that we can pay it and end the dispute. Kindly consider that.
Sorry, sir.
As your Lordship.
The date of Supreme. Stops. From the submissions advanced, there is no representation on behalf of the workman. Okay. From the submissions which have been advanced on behalf of the management, it appears that upon calculation as per the award of the tribunal, the amount payable to the sole respondent, sole opposite party has been found to be total.
As per this calculation, we have taken 50%. It is,
No, not.
then it has to be doubled. 2,60,739 as, it has to be doubled now. If your lordship gives full back wages, then it has to be doubled the amount. 2,60,739 plus 2 lakhs, double. He is just making calculation, will give the amount. Lordship may go on, give it this.
5 lakh.
Some odd amount, we'll give the details.
$72,228.
That is in terms of our calculation, as after taking 50% of the 136,114. 136 we have paid at 17B. If your lordship sees, his total amount comes to 3,96,853. Deducting 1,36,000, it comes to 2,60,739. This, my lord, if your lordship sees, we have taken 50% of the back wages. Kindly consider this, my lord. Otherwise, the calculation will go wrong. Calculation will go wrong. If your lordship is given, can I hand it over to your lordship?
Okay. Let us know what according to you is the calculation.
Kindly see this calculation, but kindly see. If not subject to your lordship permits me, kindly see this. Kindly see, my lord. 50% back wages we have considered, calculated. That is how we have arrived at this.
When was the award part?
Without any amount, they say that full back wages.
When was the award part?
Acha, when was the award? Correct.
We are in 2024.
Correct. Absolutely.
But have you calculated on the basis of full back wages?
Now, full will be double the amount. Whatever amount I have arrived at, my client has arrived at, the double the amount will be the full.
When senior counsel appearing on behalf of the management submits that the tribunal has committed gross error by awarding full back wages in favor of the opposite party. So, relying on the court's decision in case of Ripu Marbles versus Prabhakant Shukla, reported in 2010, volume 2, SPC 70, he submits that the tribunal, in the facts and circumstances of the case, ought to have awarded not more than 50% of the back wages. So he has supplied to us a calculation as regards the entitlement of the opposite party based on 50% of the back wages. Yeah, which comes out to be 3,96,853.
Correct, my lord. That is the correct amount.
Further, out of the said amount, sum of rupees 2 lakh was paid.
I'm so sorry. I beg excuse, my lord. 1,36,114 paid.
We have been. All right. So there are two amounts mentioned, 20,000, sorry. Out of the said amount, total sum of rupees 1,36,114.
Correct. Absolutely.
Was already paid to the opposite party. Accordingly, that on the date of passing of the award, that is on. What is the date of the award?
Lord, that is sometime 2012. Award is dated 29th of February 2012.
According to the management, the opposite party was entitled to receive a sum of 2,60,739.
Correct.
Admittedly, the said amount of is 2,70,739 remained unpaid to the opposite party for all these 12 years. In the peculiar facts and circumstances of the present case, we are not inclined to interfere with the impugned order passed by the tribunal and the instance of the management, especially keeping in mind the period for which the opposite party remained deprived of his entitlement. So this application is accordingly dismissed with direction of the management to deposit the entire remaining amount with the tribunal. Tribunal can be
That there, my lord, the lordship may, my lord, there he will have to execute the award. He'll have to file an execution case. So, your lordship, direction.
Deposit that. Deposit the amount, the industrial appropriate amount of the industrial tribunal, Bhubaneswar.
That's it. May I just interrupt, my lord? The proceeding is no more pending before the tribunal.
No,
Even if
not me.
so, we can't deposit it there because the case is disposed of. So,
Pay or charge. Stands. Because you have the bear with dog, can go there.
Ajay lordship.
Item 39.
But in our meet easy lordship, no? But here the grievance of the petitioners is that their father, who was an army personnel serving for the Indian Navy, was granted a concession of land of 5 acres in terms of the government circulars, which flows through from the Government Grants Act. However, that 5 acres of land, although was settled by the competent authority, that was never delivered possession to the father of the petitioners. So on this writ petition, prior to this writ petition, the father had filed a writ petition. Once he expired, the Honorable Court was of the opinion that a fresh writ application should come through by the legal heirs. And accordingly, this writ petition was filed. Because it's heritable as well. Yes, my lord, the Jawan leases are heritable.
My lord, so far as
Because the settlement was done, that has not been called into question. So that settlement, that is heritable, my lords. That is settled, my lords. It's heritable. But it's on the last occasion, if your lordship sees the order dated 25th of January 2024. That's there, my learned senior appearing for the state had sought for an adjournment to seek for instructions in the matter. Because then I'll, because it is heritable, my lords. It comes to the legal heirs. There's no dispute regarding that, my lord. If your lordship so directs, I'll file a judgment also, my lords. Your lordship looks at the first annexure, my lord, annexure, page number 10.
When had your father filed it?
But he filed it in 2004. If your lordship kindly sees that order of this honorable court also annexed. So that is page 22 of the present writ petition.
Under which provision it was allotted?
Yes, your lord, I just wanted to show your lordships that. If your lordship kindly sees page 10 of the writ petition, annexure 1. My lords are on page 10. I'll just place that letter minutes.
Which scheme the land was?
Yes, my lord, there's a circular which has come through from the Government Grants Act.
Where is that, sir?
Yes, my lord, I'm just referring to that, my lord.
Where is that, sir?
But page number 10, if your lordship sees.
Or that circular has been referred to in that
Yes,
communication.
yes.
Where is that circular?
Yes, I'll file the circular then. I'll file.
Suppose in some communication,
My lord.
provision is referred to.
I have understood what I've understood your lordship's request. I'll file the circular. It's a circular of 1966.
See what is the as the relevant file has since been destroyed, a copy of eligibility certificate cannot be issued in favor of the task as paid for by him.
Yes, brother. Thereafter, they say, because this is the competent authority, the Home Department has directed for.
So how can we decide in writ jurisdiction?
No, but so far as the allotment is concerned, my lords, there's no dispute.
Where is that?
Yes, my lord. If your lordship kindly sees the settlement order of the Tahsildar, who is the competent authority. Plus that I have annexed.
If the competent authority does illegality, then what can be done?
No, but there's no illegality. The grievance is, my lord.
You don't have the scheme. Your documents were destroyed. Subsequently, Tahsildar settled. So how can we decide whether Tahsildar had rightly settled in your favor or not?
Because that is not called into question, my lords. The government also doesn't dispute that settlement order. The Tahsildar having settled it pursuant to that, there's no dispute, my lords. But that particular settlement order, which was made by the Tahsildar, was pursuant to the annexure 1, and that order has not been called into question. The state also doesn't dispute it. What the state wanted on the last occasion
When
was.
did your father die?
But I don't have the exact date, my lords. But-
You don't have the date when your father died.
No, but I don't have the exact date.
What is this?
So I will have.
How could you file this petition then?
My lord, by virtue of the liberty granted by this honorable court, yes, my lord, he died on the 11th of May 2011. It's mentioned in the pleading of my writ petition, my lord. Page number 6 of the writ petition.
Come ready, we are not satisfied.
My lord.
1 week. It's not the way. You are a young counsel.
My lord.
Why should you say you don't know?
But I'm sorry, my lord.
It is there in the.
Yes, my lord, it is. Should have seen better, my lord. I'm sorry.
Item 40.
All right, 1 week.
My lord.
Item 40.
And you support your affidavit also.
Yes, my lord.
I prepared a small date chart, my lord, in this case.
40.
The petitioner was,
910. Yes.
the petitioner was serving as an assistant professor of pharmacology under the MKCG Medical College, my lord. After 20 years of service, continuous service, on 5/9/2005, he applied for voluntary retirement under Rule 42 of the Orissa Civil Service Pension Rules, my lord, and he requested for retirement from government service with effect from 6/12/2005. Had 90 days period, my lord. That his voluntary retirement application was forwarded by the DMET to the government on 1/10/2005, my lord. Within 6/12/2005, when the government did not communicate anything to the petitioner for his retirement, my lord, he waited till 12/1/2006. And on 12/1/2006, she relinquished his charge and retired from service, my lord. On 14/9/2007, government accepted his application for voluntary retirement with effect from 5/12/2005, my lord.
So what were you doing after 5/12/2005?
I was after 5/12/2005, I continued there.
You
In the-
discharged your services.
Yes, my lord. I continued till 12/1/2006.
We understand that. We are just putting a question. That what were you doing after 5/12/2005?
I was continuing in the said post.
So you discharged your duties on 6/12/2005,
Yes,
7/12/2005,
my lord.
till you attained the age of superannuation?
No. Till 12/1/2006, I continued there.
Yes, 12/1/2006
Six.
comes after 5/12/2005.
Yes.
So in the meanwhile, you are working, discharging your duties. This is your submission.
No, my lord. On 12/1/2006, I relinquished the charge.
Why did you relinquish?
I had applied for voluntary retirement.
Okay, what was the date of your superannuation?
As per my voluntary retirement application, the date of retirement is to be 6/12/2005.
There is difference between retirement and superannuation.
Yes, sir.
So superannuation may be a reason for retirement. Superannuation will come only when you
Attain the age of, yes.
Alright,
Yes.
so this is what we are asking. What was the date of your superannuation? All right, forget that. So what was the date of your application for voluntary retirement?
On 5/9/2005.
Yes. And what is wrong with this order?
Well, my limited prayer is that since I continued them in the post till 12/1/2006, my pension should be fixed, taking into my service till 12/1/2006. This is my limited prayer, my lord.
Right.
Well, because my lord, rule 18(2) of the Civil Service Pension Rules, my lord, condition subject to which service qualifies. Service does not qualify for pension unless it is rendered in a pensionable establishment post, my lord. I am holding a permanent post and pensionable post, my lord.
No, where is the provision for voluntary retirement?
That is Rule 23, my lord.
And your
No, 42, my lord. Rule 42, voluntary retirement on completion of 20 years qualifying service. At any time after a government servant has completed 20 years qualifying service, he may, by giving notice of not less than 3 months in writing to the appointing authority, retire from service. The notice of voluntary retirement given under Sub-Rule 1 shall require acceptance by the appointing authority.
please come to the proviso.
Yes,
Let
ma'am.
me know.
Yes, ma'am. Provided that where the appointing authority does not refuse to grant the permission for retirement before the expiry of the period specified in the said notice, the retirement shall become effective from the date of expiry of the said period.
So what is the date of expiry of the notice?
That is, my lord, 5/12/2005.
This is what they have done.
My lord, rule, my lord, only my limited grievance is that, my lord. Your lordship may kindly.
The only wrong which they did was, they might have done, that they allowed you to work even after 5/12.
After, till, my lord, I'm till 6/12/6/1, my lord, 12/12/2006, I continued, my lord.
How?
Because
How are you continuing?
no intimation was given to
No
me.
intimation was required. This is what the proviso says.
My lord,
Provided by that, the appointing authority does not refuse to grant permission for retirement before expiry of the said period, that is 3 months. The retirement shall become effective, so it became effective. So there is just a communication, subsequent communication.
your lordship may kindly see rule 18.
Rule 18.
18. 18(2). The entire continuous temporary or officiating service under government without interruption in the same.
Sir, sorry, you are smiling because you know the weakness of your case.
Only limited grievance is, my lord, only retired employee will get some more pensionary benefit only.
Now, can we put one more question? Why did you stop working after 12/1/2006? Did someone tell you?
I get a better offer in some other establishment. There was no avenue for future promotion in the, for that.
See, you knew that with effect from 5/12/2005, you will not be there in service. Because you had given notice. According to you, continued even after 5/12/2005, all right, might have continued, might have been allowed to continue till you attain the age of superannuation. But one day you decide on 12/1/2016 that thus far no further, I will not.
That period should be taken into account for calculating the pension.
And we are exercising that jurisdiction.
Then the application has put to challenge an order dated 15/9/2007 passed by opposite party number 1, right, opposite party number 1, whereby the petitioner was informed about extension of for voluntary retirement effective from 5/12/2005. So, the limited prayer of the petitioner is that the limited ground to question the impugned communication which has been taken by counsel appealing on behalf of the petitioner is that the petitioner had in fact discharged his duties till 12/1/2006 as assistant professor.
Yes, ma'am.
As an assistant professor in the Department of Pharmacology in MKCG Medical College.
Barampur.
Barampur. Oh. Certain facts relevant for adjudication of the present writ application are not at all in dispute. The petitioner had made an application seeking voluntary retirement on 5/9/2005 under Rule 42 of the visa pension rules. Visa Civil Services bracketed pension rules 1992. The top. Sub-rule 1 of Rule 42 permits a government servant to apply for voluntary retirement by giving notice of not less than 3 months in writing to the appointing authority for Sub-rule 2 of rule 2 further requires that the notice of voluntary retirement given under sub-rule 1 shall require acceptance by the appointing authority. So, the proviso to sub-rule 2 is significant in the present matter, which reads as under. So, it clearly mandates that if the contemplates that if the authority does not refuse to grant permission for retirement before the expiry of period specified in the said notice, bracketed not less than 3 months, bracket close, comma, shall become effective from the date of expiry of the said period. So, the proviso below sub-rule 2 of rule 42 of the pension rules became operative the moment the period of notice mentioned in the application seeking voluntary retirement came to an end. That is on 5/9/2005. So, the impugned judgment, the impugned letter and as mentioned in the notice of the petitioner itself, comma, he who retired with effect from 6/9/2005. So, the later dated 4/9/2007, comma, in the present matter cannot be said to be acceptance of the petitioner's application for voluntary retirement. Rather, it is merely a communication regarding his retirement which date from 5/12/2005, which became effective by operation of the proviso on below sub-rule 2 of rule 41 of the pension rules. So, we do not find any merit in this application in the background of the facts which are admitted. This application has no merit, it is accordingly dismissed.
Mr. Acharya,
My lord,
we will take up your matter after we finish the list.
Lord, I will wait.
All right.
I'll
So
wait.
please wait.
I'll wait.
We hope. We should-
Item number 41.
May I please, lordships? May I pray for 1 week time to file the rejoinder affidavit, Mila?
1 week for rejoinder and file additional affidavit also
My lord,
in support of your averments in the writ
my lord,
petition.
my lord.
We will.
Item 42.
Item 42, may I please, Your Lordship? Your Lordship, I pray for 1 week time to, Your Lordship, I've received the brief yesterday. I pray 1 week time to come more research so that I can assist this honorable court, Your Lordship.
When was the writ petition filed?
Your
When was
Lordship,
it
it was of
filed?
2014.
Why have you received the brief?
Your
today?
Lordship, on behalf of Mr. S.K. Patnaik, I've received it yesterday.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Bless Your Lordship.
So, and counsel for the petitioner must ensure in the meanwhile that an additional affidavit is filed in support of the averments made in the writ petition. This is a writ petition.
Yes, Your Lordship.
All right. Yes. Next.
Item 43.
43, Your Lordship, on behalf of Senior Counsel Mr. J.R. Dora. Your Lordship, in this case, Lordship, after putting forth 29 years of service, Lordship, on the representation of OP3, that representation was made after 23 years of the regulation of the petitioner and after 13 years of the final gradation promotion list, Your Lordship. Considering that the opposite parties have reverted the petitioner service to that of to the bottom seniority, Your Lordship, to junior LD assistant, junior LD assistant, Your Lordship, and thereby relieved the petitioner. Then relieved the petitioner, Your Lordship, as that post of junior assistant, LD junior assistant, was only one sanctioned post, and that already one person of OMS rule was appointed. Hence, after 29 years of service, the petitioner lost his job, Your Lordship, without any giving any chance of natural justice and without any opportunity of hearing, Your Lordship. Lordship, kindly submit the brief facts of the case, Your Lordship.
No, but whether affidavits have been filed on behalf of the estate?
Yes, Your Lordship. Lordship, return notice also there, Your Lordship.
Everything is there.
Your Lordship, I'm placing the return.
So the short submission which you are making is that whatever decision has been taken against you
Yes,
has
Lord.
been taken without giving you an opportunity of hearing.
Your Lordship.
This is your submission.
Yes, also, Your Lordship, the representation that was considered of OP3, that was made in gross delay and laches, Your
No,
Lordship.
forget that. Forget, even if that was read within time. Yes. Is it correct?
No, my lord. In the gradation, what has happened, my lord? In the gradation list, he was lowered to it as in portions of the direction of tribunal in other case, and also in conformity the order passed of the Honorable Apex Court, his position was changed in the gradation list. As a consequence thereof, he was reverted to the post of junior clerk. That is the fact. And he has challenged it before the Honorable Tribunal. And you will also may see that order of the Honorable
So
Tribunal.
according to you, the gradation list was prepared in accordance with the directions issued by the Central Administrative Tribunal,
State Administrative.
State Administrative Tribunal, which was approved by the Supreme Court.
Yes, ma'am.
That's all.
That's all. You also can find it from that order of the tribunal, my lord. You also may see.
No, not order of the tribunal. Where is the order by which he was reverted?
Yes, my lord.
Annexure 5,
Page
Your Lordship.
12, Annexure 4, my lord.
Annexure 5.
5.
Page 16, Your Lordship.
Yes, then what happened?
Your lordship. Your lordship.
Yes, approved the London Tribunal matter in OA number 805 CF 2009. Lordship can find it from page 16, annexure 6.
Page 16 is annexure 5.
16, my lord, 16. Annexure 6.
Oh no, annexure 6 and annexure 5 is at page 16.
My lord, he has given that brief in
Page
my,
19, your lordship.
in my brief that has been.
I was seeing that. Annexure 5, office order.
My,
No, you are referring to the office order.
no, I am referring the order of the tribunal, my lord.
Order of the tribunal is annexure 6,
My
page 19.
My page.
Right. You may be right, page 16.
My lord.
Yes.
There, Lordship said that tribunal my lord, held that the fixation of intercessionity is correct in view of the law laid down by the Supreme Court in the case of State of Odisha versus Sukandi Mahapatra and as well as the Odisha Ministerial Service Bill 1975. What has happened? Two dates are important, my lord. What has happened in his case? Initially, he was appointed not in accordance with the OMS rules 1975. The opposite part number 3, he was appointed in accordance with the rule 1975. A relaxation clause is there in 75. Two dates, my lordship, in 1980. I am giving that date, my lord.
No,
he was appointed.
See, there can be 3 circumstances.
Yes, my lord.
One, some order passed by the tribunal, affirmed by the Supreme Court. While carrying out the orders of the tribunal, the seniority list was to be seniority was to be refixed.
Right.
And in that course, in implementation of the order of the tribunal, his gradation went down, his seniority went down, and the ultimate consequence was that he had to be removed from service. This is one situation.
Yes, ma'am.
The other situation is that what you are submitting, that his initial appointment itself was something bad.
Yes.
And therefore a decision was taken to remove. This is second situation.
No, my lord, not remove. What has happened, my lord?
You have not been removed.
Not removed. That
You have been removed, your lordship.
not removed. Not removed, my lord.
Your lordship, we have
You have been
relieved-
reverted.
We have been reverted and relieved, but we were assigned to the lowest rank, your lordship. That is a junior. We have promoted. First, we joined as junior LD assistant. Then we were promoted to senior assistant. Then we promoted to SO, your lordship, section officer. So what they did is they reverted back to junior LD assistant, your lordship. But that junior LD post, your lordship, that was a sanctioned post, and only one section post was there, and that they recruited through a OMS rule, your lordship. So thereby petitioner was completely left jobless because already one
jobless.
Your lordship, because one no. Yes.
Why are you saying jobless?
No, your lordship, as one sanction post of LD system was there. In that one sanction
There were 3 posts A, B, C. You were holding post C, which is
no, your lordship, there was only one post of junior LD assistant. The petitioner joined as junior LD assistant. After 6 years of service, he was promoted to senior assistant.
So that is B, senior assistant.
Yes, your lordship. Then after more years of service, he was promoted to section officer, your lordship. C. When this after representation of OP3, they reverted the petitioner to that of again to LD assistant.
A.
Your Lordship. But the said LD assistant post, they had given to someone from OMS rule, Your Lordship. And hence petitioner could not join anywhere and left.
Could
Your
not
Lordship.
join? You were already there in service.
No, Your Lordship. That junior.
So after having been relieved from the post of section officer, you were to be reverted to that
LD junior assistant.
LD junior assistant or whatever.
Your Lordship.
A post A.
Your Lordship.
But you have not been allowed to join even that post.
Yes, Your Lordship.
And you are out of service.
Yes, Your Lordship.
As on date.
After 29 years of service. Your Lordship, may I place the crux is quite different from that. What
So let us understand broadly the issue involved. So, so you are not in job according to you?
Yes, Your Lordship.
He says you are working.
I'm saying that he was reverted. That order says.
See,
Order says he was reverted.
you must say, you must take a plea. There are two things.
Yes, then I'll take instruction specific to that effect.
Specific to that, even if he was holding post C, which was a promotional post,
Well,
and he was to be reverted back to post A,
yeah.
then procedure was required to be followed under in accordance with Article 311.
Well,
that amounts to reversion. So he was required to be given some opportunity, some reason you could have given that this is the circumstance in which, not by way of punishment, but for any reason.
In fact, it's not a punishment. No doubt this is a punishment.
Whatever.
Yes,
Let us see. Not a punishment. But in any case,
yes, madam. His service condition is affected.
Then service condition, there are two circumstances: removal from service and no such person as aforesaid shall be dismissed or removed or reduced in rank.
Yes,
after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard. So whatever you could have said, that this is the circumstance.
Your Lordship, also there was no inquiry held, Your Lordship. Directly on considering the representation of OP3, they decided, Your Lordship.
Seek instructions.
Yes, ma'am.
Lordship, one page may kindly be seen, page 18, Your Lordship.
We will see that, we will hear you.
Your Lordship.
Because your time is also very precious. And so is ours.
Your Lordship.
So on the next day,
Oblige, Your Lordship.
as requested on behalf of the state, so as to seek further instructions as regards the actual status of the petitioner, that is whether he is in service or not, comma list, presently he is in service or not, comma list this matter on 2 weeks.
Your Lordship, petitioner is already retired.
Huh?
Petitioner is already retired. He had retired on the age of superannuation on 2013. It's only that from 2009 to 2013, he was not working.
As on 2000. As on which date?
Your Lordship, 39, 2013. 30th September 2019. 30th. Lordship.
When did you retire?
On 30th 9 2013.
And since when you were not in service?
2009, Your Lordship. I'm submitting. See, 24/3/2009.
Service as on 24
March 2019.
As on
2009.
As on 23 March 2009.
Your Lordship.
All right.
Your Lordship.
So after that you retired.
I've retired on 30th 9 2013.
Well,
attaining the age of superannuation.
So in your residence you retired.
Your Lordship. For that period of time, he was not working.
Sir, Counsel, when you are not in service, where is the question of your retirement?
Your Lordship, there on the order, on the basis of order, it is settled, reverted and relieved. Your Lordship. As there was already that post, that lower post of LD assistant was filled up, they said when a vacancy arises, we'll give you.
So did you go there?
Your Lordship.
Did you go there to join or do
Yes,
something?
Your Lordship. That is at rejoinder, Your Lordship. Annexure 13.
Did you receive salary?
No, Your Lordship. We are receiving only provisional pension. We did not receive any salary.
After 2009, did you receive salary?
No, Your Lordship. From 2009 to 13, I've received no salary, Your Lordship. That's what you're praying in
I'll
this.
also take instruction regarding that period.
Peculiar.
We have given multiple joining reports, but they have not considered.
Let us see.
Item 44.
I'm for the opposite party.
No one appears on behalf of
No, my lord, I have.
Government.
Sorry,
State.
sorry. my lord.
Yes.
State have to file rejoinder, madam. There is notice, state have to file rejoinder.
Has filed a counter. I will file a short rejoinder 1 week.
And counsel for the petitioner, that is State of Orissa, seeks adjournment to file a rejoinder to the counter affidavit filed on behalf of the opposite parties.
One opposite.
Opposite party number 1.
1 week. I will file because I have received the draft rejoinder 1 week.
Is this case on 1 week? These matters are pending since long. 2016.
Well,
We should take up matters year-wise.
I'll within 1 week. I'll
Item 45.
Yes, sir.
Millard, item number 45, while appearing for the petitioner, I'm very sorry to inform that the petitioner has died during the subsisting period of. And also another thing, I must bring it to the knowledge of the court. There is a covered matter that is in a batch of writ petition, WPC number 1608 of 2014. Almost 39 writ petitions have been disposed of by a covered matter. I'll give a copy to my learned friend. So let him examine. And by next date, I'll be filing the substitution petition because none of the family members are staying at Bhubaneswar. That is the whole difficulty. Because none of the family members are staying at Bhubaneswar, they are staying outside. Although I have communicated the order of the court, the substitution petition could not be done.
So when did he die?
The petitioner died.
When?
He is not responding since August. That's why I have.
For last 6 months, this case is being adjourned for filing of substitution petition.
Let it.
Millard, may I say one thing?
You can later again. It is stated by Mr.
Ramakan Solanki.
Huh?
Ramakan Solanki.
Mr. R.K. Sharangi, that Ramakant Sharangi, that the appellant died during the pendency, petitioner died during the pendency of this writ application. And despite sincere efforts having been made, he has not been able to contact his legal heirs. So stop. In such view of the matter, the present writ application abates. So stop. We make it clear that we have not gone into the merits of the case. So stop.
May I pray one thing, Millard? Since in similar circumstances, the matter relating to the resumption of the land under Section 3B of the OGLS Act, almost 39 writ petitions have been disposed of by a common order.
Just we further make it clear that I further observe that the court expects the authority to treat heirs of the petitioner, bracketed since deceased, similarly with other similarly situated persons. Will that serve
Yes,
your purpose?
my lord, in view of order dated,
No, not in view of, whatever, whichever is order, they will take care of.
That is sufficient.
That is the best order which you could have got.
That is the best.
but I am undone, I am undone because the matter has been entrusted to me, and in front of me, I am looking at the similar other persons have got the benefits.
Therefore, we have mentioned this is the writ petition we cannot see.
May I make a very small prayer, my lord?
Yes.
But let the
Except
authority
adjournment. Any prayer.
my lord, accept the adjournment. Lordship may direct the state authority to examine the matter. If it is covered,
We cannot do that.
Sense of the
What else? Rest of the reason.
Your writ petition has been allowed in the absence of petitioner. Just think of situation. All right.
Item 46. May it please, Milords. Milords, item 46, Milords, challenges the virus of a particular provision, section 194A3 of the Income Tax Act, Milords. My lords, the department have filed their reply, but my lords, since it is challenging the virus, your lordship sees the last order. The Union of India, my lords, was called upon to file their reply. We did the last order, my lords.
Which date?
My lords, this is 22nd January, my lords. 24.
Order number?
Order number 7, my lords.
What is there?
They have not filed their reply. The Union of India, my lords, have not filed their reply, my lords. They may be directed to do so, my lords.
So what reply is required to be filed when virus is under challenge?
Yes, yes.
What reply?
There's the virus, my lords, of section 194A3, clause 3 of the Income Tax Act, my lords, has been challenged, my lords. And therefore, my lords, your lordship's last order calls upon the Union of India to file the reply.
Therefore, what reply? What? Tell us.
My lord,
you are challenging the legality of statutory provision.
My lords.
Maybe on the basis that it violates any other statutory provision or any constitutional provision.
Yes, my lords.
These can be only two grounds.
My lords.
So what reply the Union of India shall file or can file?
Very well, my lords. The question, my lords, that it is discriminatory. That is the question, my lords, before your lordships on the test of constitutionality.
Where is your prayer?
Yes.
That it is violative of Article 14?
Yes, please. My lords will kindly come to page 28.
Page 28?
Yes, please. Running page 28.
Page 1, paragraph 1. You say it is violative of Article 14.
Yes, yes. I was just showing the prayer.
We will see. See, yes.
Well, this particular repetition representing pertaining to the income tax, my lord, I am representing the income tax. So kindly allow to time for further instruction.
This provision was subject matter of challenge in another proceeding anywhere.
No, my lords. My lords, I have, my lords, before I came to your lordships with this writ petition, my lords, I had done a research, my lords. There was no such writ petition. My
All
lords.
right. So, in fact, normally the virus of a central act is defended by the Union of India, not by a department. Whatever, are you ready to assess this court?
Probably, Millards, therefore, the reply of Union of India.
The moment you challenge the validity of statutory provision, there is no affidavit, nothing is required, no fact is required.
Then your lordships, I'll take notice to the Council for the Union of India, Millards. Somebody.
On behalf of London, I'm appearing. I will take some time because he's out of town because of some medical urgency. And I need some time for giving instruction in this case.
By way of last indulgence, this matter of virus is pending since 2018. For 5 years, as requested on behalf of the Union of India, by way of indulgence, the matter is adjourned to 3 weeks.
3 weeks.
Yes.
Great. Item number 47.
Pursuant to my lord's order, I have deposited the requisites for issuance of notice, my lord, because nobody was appearing. Even though the matter was ready, nobody was appearing. So my lord directed for fresh notice and I have deposited. The order of the tribunal is under challenge. One name appears in the cause list, my lord, Mr. Lalit Sahu. But the notice was sufficient or not, that I have not found out.
So when did you deposit the?
My lord, on 25/1/24.
Awaiting service of notice services. Service. Valid service.
Yeah.
Then. Well, at least. Can hear it on merits.
Other side is not appearing.
There is no representation on behalf of the OP number 1.
OP number 1, 2, 3, and 4 also, my lord. Opposite parties.
Opposite parties 1 to 4, despite service of notice. Stop. Awaiting their appearance. List this matter on 2 weeks.
Item number 48.
1 to 5, man. That my lord directed 1 to 4, 1 to 5.
1 to 5.
Item number 48, my lord. I pray a short adjournment because of my illness, my lord.
Oh, yes.
I am not fully well.
All right. Yes. When do you want?
Next week, any date, my lord, you
1
lordship.
week has requested on behalf. Please take care. Petition is being withdrawn, madam. WPC 13270. 13270. Withdraw.
My lord, if it is withdrawn, my lord, my petition will be allowed, my lord.
We will see. Once you recover, we will see.
My.
The effect of withdrawal also. Many.
Item 49.
Item 49, who is time to file additional affidavit? Who is time to file additional affidavit?
Additional affidavit. Yes.
Item 50.
So who is for the petitioner?
I'm for the petition.
50.
No, my lord, in 50, my lord, I'm for the petition.
50
For the
for-
Union of India, my lord.
Acha, in the other case you were talking. Yes.
We are for the Union of India, so we are, and for the petition, my lord. In this case, my lord, we need some time to file an additional affidavit
Additional affidavit, 1 week.
along
3
with a
weeks.
written note of submission and date chart, my lord.
If that is your choice.
We'll file.
My lord, in item 50, I am appearing for opposite party number 1, my lord. In compliance to my lord's order, fresh notice issued to opposite party number 2 to 7. So far, there is a noting regarding service of notice on opposite party number 6 and 7. May I pray, my lord? Your lordship may direct the office to verify whether notice has been served to opposite party number 2 to 5 or not, my lord, so that this case can be taken up finally. And the interim order is continuing against me, my lord.
Who are 2 to 5?
They are,
Private?
the candidates who have selected, my lord. Their selection is under challenge.
And 6 and 7?
They are also private opposite parties, my lord.
So even if in their, your case and case of 2 to 5 are similar.
My case is before the law tribunal that 2 to 5, though they have secured less mark than me, but they have been selected and promoted, my lord. Though I have secured more marks, but I have not been.
So they form a class different from you.
Right.
And they are not appearing.
They are not.
Yes, service of notice. Right. Are they working?
Yes, my lord.
2 to 5?
My lord.
Where?
Has been delivered.
Huh?
Has been delivered on 6 and 7.
6, no, 2 to 5.
They are working as postman in different places of Odisha, my lord. And their designations have been furnished by the petitioner in the cost title, my lord.
Yes, sir. 2 to 5 valid services.
Served. It has been, it appears from the records that services have been, notices have been served upon opposite parties number 2 to 7. First off, despite service of notice, opposite parties number 2 to 5 have not entered appearance, though opposite parties number 6 and 7 have entered appearance through.
No, my lord. Only opposite party number 1 is appearing before my lord. Notice has been served as reflected in the cost title. So far, opposite party number 6 and 7 is concerned, my lord. So far, 2 to 5 is concerned. There is no noting in the cause list. Whether
It has been there. Not entered appearance. Though respondents number opposite parties number 6 and 7 have entered appearance through wakalatnama.
2 to 5 are not appearing. In spite of service of notice, Your lordship only said the notice has been served on opposite party number 2 to 7 so that this case can be taken up finally.
Huh? 6 and 7. You are representing whom?
Only 1, my lord. The applicant before the law tribunal.
Service of notice, response numbers 2 to 7 have not entered appearance.
Obliged.
51.
My pleasure. Then the, I beg pardon, we also learned DHA commit may be taken up next week.
But I am for the petitioner, my lord. The order impugned is under annexure 14 to the writ application.
No, he is seeking adjournment. What should we do? We are seeking your permission.
Oh, my lord, your lordship. The last two occasions they have taken the time.
Don't take, by way of last indulgence, on the request made on behalf of the Union of India, is this matter on 1 week?
52.
Milord, item 52. Today we have filed the additional affidavit, Milord. Opposite party number 4 has filed the counter affidavit, but copy has not sought to us. And Milord, in this case, senior advocate Mr. Jagabandhu Sao is appearing, but his name has not been reflected in the list. And Milord, may I pray for next week adjournment, interim order to be continued, Milord.
My lord, petitioner has participated in subsequent tender, my lord. Petitioner
No, but
was
you should have
selected.
given her copy of your counter affidavit.
I'll give that counter affidavit.
Give her a counter affidavit.
My
And 2, why the name of senior counsel should appear? Senior counsel should not appear. Why?
I may be excused, Milord.
Senior counsel is not bound by wakalatnama filed by someone else. Senior counsel's engagement is for a particular day only.
Milord, may I pray for next week adjournment?
Let a copy of the counter affidavit filed on behalf of respondent number, opposite party number.
4 mile.
4 be served on London Council for the petitioner by tomorrow. Stop. List this case on
Milord, interim order to be continued.
1 week. Stop. The interim order shall.
There is no interim order. Result is the result, subject to result of it.
Interim order, madam.
Yes, Milord, yes, there is an interim order.
Subject
But-
to result of it.
but I
That
have
is
got
not
the-
an interim order, madam.
Milord, but I have got the instruction that interim order is to continue.
Who has instructed you?
On behalf of Mr. Tapas Kumar Acharya, I am appearing.
There is an interim order.
There is an interim order.
No, my lord, there is the order subject to result of writ petition.
That interim order is no interim order.
Item number 53.
My lord, this matter is infructuous, so.
Infructuous.
Item 54.
Before, my lord, I have given the corrected affidavit.
Knowledge.
This case, my lord, your lordship may recall that relating to GST. Last week, your lordship granted some time and gone through it. Well, there is no point to defend, my lord. So the lordship may direct as appropriate, my lord, dispose of the case. I'm for opposite party, it go.
Here they varied the condition of the contract. Here they varied the condition of the contract after they execute the work. And on the basis of
After
such
execution
variation,
of the agreement that was
on the basis of
subsequently
such
withdrawn.
variation, they are seeking for recovery. So that your lordship heard
That
in
should
the
not have been done, but my lords may direct.
That's order.
My lord, we filed the counter affidavit, but
They
we
have
have
filed.
filed, we have filed.
May I just take your lordship through once again, just is by our letter of our dated. Lordship may kindly have that page 21. Page 21 is the letter of our that is dated 27th March 2018. Here, my lord, your lordship at page 22, there is a condition 9, clause 9. The contract is to bear the building and other constructions worker welfare cess, GST and all other local taxes and royalties. Now, this condition, they have verified later dated 18/5/2018 that your lordship find out page 65, much prior to commencement of the work. Page 65, Annex 4. Here the reference letter is letter number 27th March 2018. That condition, and on the basis of that I executed the work, and all this work was completed in March 2021. I have annexed the completion certificate. That's the next page 66 is the completion. They acknowledge the completion. Page 65 is the conditions which they withdraw. My lord, it's GST made explicit. Now I have completed it, and this is 24/3/2021. They accepted that completion is done. Now, my lord, these are GST bills. I'm not troubling. Then the next letter is.
Just a minute. Listen to the order, and if you find we are committing any mistake, just point it out. We can do that. We do commit mistakes. The facts of the case are not at all in dispute. The petitioner number 1, please take, is company engaged in the business of execution of the works contract, whereas petitioner number 2 is managing director of petitioner number 1 and a shareholder of the said company. Full stop. Pursuant to tender notice dated 29/7/2017 inviting bids for execution of work of construction of court construction of driving track at Kaunchar, unquote, comma, the petitioner had submitted his bid. The bid and was successful. Full stop. Letter of acceptance was issued by the opposite party number 2 on 27/3/2018, whereupon the petitioner had submitted the requisite security deposit and had also deposited additional performance security. Stop. Clause 9 of the letter of acceptance, said letter of acceptance dated 27/3/2018, and the agreement clearly stipulated that the rate finalized rate was inclusive of GST. Stop. It is also an admitted position that the petitioner had successfully completed execution of the work when?
March 2021. March 2020.
In March 2021, 21. Full stop. It is the petitioner's grievance that after having executed the work, comma, the opposite party, number 2, which is that, where is that?
That's 17/9/2021.
Where is that?
That page 75.
Page 75.
Actually, in between, my lord, they have revised that clause 9.
That we want to.
That at 18/5/2018.
65.
65. Prior to commencement of work, the revision has done.
Full stop. Prior to this, the revision was done. Then what is wrong in that?
No. They are now revising that.
9. This is what we are saying. Where is the revision?
Revision is at page 65.
Revision is at page 65.
And the further revision is at page 75.
That is what we want to say.
Yes, ma'am. So I am on the basis of 65.
Yes.
Which was inclusive of
Seven.
GST. Yes, madam. Initially, it was inclusive of GST. By revision, they made it exclusive of GST. Now they are saying that we are withdrawing that.
Petitioner is aggrieved by Annexure 7.
Yes, ma'am. Annexure 7.
It is pertinent to note that this is written by whom? Annexure 4?
Annexure 4 by this Chief General Manager, Civil.
IDCO, my lord.
IDCO, my lord.
IDCO?
Yes, ma'am. Corporation letter.
This is a letter of IDCO, my lord.
That on 18/5/2018, the Chief General Manager, bracketed Civil, IC in charge, had in his communication to the divisional head, IDCO, Jajpur.
Yes, ma'am.
Well,
Jajpur Road Division, Jajpur, had comma with reference to clause 9 of the said agreement,
Letter of acceptance.
letter of acceptance, had clearly mentioned that it shall be read as under quote serial 9. The contractor is to bear all local taxes, comma cess, comma ferry, comma toll charges, comma royalties, and any other charges, but excluding GST, CST, and GST as applicable.
GST.
GST.
Only GST.
Sorry, but excluding GST, full stop. GST as applicable will be borne by IDCO. Unquote. Full stop. After completion of the work by the petitioner, the Chief General Manager Civil, in its communication addressed to the divisional head, IDCO Jajpur Road Division, Jajpur, regarding the same contract noted as under colon dash quote the technical sanction to the estimate for work noted above or later date 6/9/2021 for the work noted above was accepted based on pre-GST rates and the tender was also approved accordingly. So stop, you are therefore
Was accorded based on.
was what
My lord,
work was
my lord, it is accepted, that is accorded.
accorded, accepted and accorded based on pre-GST rates and tender was also approved accordingly. So stop, you are therefore requested to follow the guidelines issued by Finance Department Office Memorandum referred to above, bracketed copy enclosed for implementation of GST for works. Full stop. Next paragraph. The instructions issued on payment of GST by this office later dated 1037 dated 18/5/2018 is withdrawn. Full stop. Payments made to the executing agencies may be adjusted accordingly. Unquote. Full stop. The petitioners have questioned the subsequent decision of the opposite parties as contained in the said communication dated 6/9/2021 on the ground that the concerned opposite parties have unilaterally varied the terms of letters of acceptance, which is wholly arbitrary and illegal. So stop. Next, after having heard learned counsel appearing on behalf of the petitioner and learned counsel for the respondents, we are of the considered view that the opposite parties could not have varied the terms contained in clause 9 of the letter of acceptance after the work having already been executed by the petitioners. Stop. The impugned communication dated 6/9/2021 cannot be sustained and is accordingly set aside. Stop. Consequences of the quashing of the said communication shall follow. Do you want any further?
Annexure 8 is the consequential letter. Annexure 8.
Therefore,
Annexure 8 and 10.
all actions taken taken based upon the said communication dated 6/9/2021 are held illegal. The opposite parties shall be required to proceed accordingly.
Item 55.
Well, I am permitted to file the additional affidavit.
File. But we have to hear a matter. The one matter was fixed today. Mr. Acharya is sitting here since 2. So we'll take up your matter later. We will take up matter which was fixed as the first case.
May I please, madam?
He is not here.
Item 61 may be taken next week.
No, please come, please. Please come. Yes, what is the matter?
The matter is that after the death of her husband, since 1998, the petitioner has been working as a lady attendant. The petitioner has been working as a lady attendant after the death in a college, after the death of her husband. And since near about for 25 years, she has been working. But due to Your Lordship, kindly have a glance at the block grant order 2014 as at page 44, my lord. It will be visible. Man, she is entitled to get granted with effect from 2014 as she has joined prior to 1/6/2008. Your Lordship, kindly have at page 44. 44 towards last. It is para 3, last para, my lord.
Just a minute. You were appointed by whom?
By the governing body of the college.
Governing body of the college is a private body, or?
No, it is an aided college.
Then how can you claim that government should?
That is granted provision is there in Odisha. As per the granted of 2009, the petitioner was entitled to be receive granted block grant. But due to the shortage of period, that means as she joined on 7/12/1998, so she got deprived. Naturally, another granted block grant order came in 2014. That is block grant order 2014. As she has joined, there is stipulation here. May I permitted to read here only that the this 44 page.
All the service matters are placed.
I am translating in Odia, sorry, in English. That is, one who has eaten water rice, he is allowed to get warm rice. But one who is deprived of getting that water rice even, he will not be allowed to get anything.
Then you are mistaken. This proverb will not apply in court proceedings. All right. That may apply.
In this case particular, what has been done?
Oh no, there is no necessary. You are challenging what? How virus is under challenge in this case?
Virus is due to
virus of what?
Virus of para 2 of 0.4. This in this.
What is para 2.4?
My lord. See, at page 63.
Is that a statutory?
It is in rule.
The question is whether that has a statutory character. Is that statutory?
Statutory rule.
If someone says that it is rule, therefore it will become rule, statutory.
No, rule has statutory by the order of the governor. It has been done. This is order by the statutory.
No, we are not satisfied. It is not statutory in character.
Yes, this is the statutory, my lord.
Let us see.
49 page, kindly have a glance at page 49. No, 49 by order of the governor. It has been done. It has been done. Section rule in the
Mr. Counsel, the transfer order of an officer is issued under the order of a governor. Therefore, that is statutory.
That it has been issued is by the order of the governor.
Do you understand the meaning of statutory? What?
Statutory, anything, the rule or the act that has been passed by the state legislature or the under the order of the governor. Section granted provision. Kindly have a glance at the page. Kindly have a page 44.
Page 44.
My lord. Next question. Three.
Yes.
The teaching about last paragraph. The teaching and non-teaching staff of the non-government aided colleges, which are covered under the Orissa non-government colleges, junior colleges, and higher secondary schools granted in 2008, and the Orissa aided colleges, aided junior colleges, and aided higher secondary schools granted in 2009, who joined on or before the 1st June 2008 in respect of the education.
You are reading which page?
In page 44, ma'am.
You should not have read page 44. You should have read for page 43.
43 is the opening page. Really, I'm saying.
So whether this is statutory in nature is the first question.
Yes, my lord.
We want to know.
My humble submission is it is
Just a minute.
My lord.
Where is this? Odisha Education Act?
Odisha Education Act is 7C.
Let us see.
7C. One 37 page, man. Granting here, man. May I permitted?
Just a minute. This is purely executive in character. 7C is not does not give any rule making power. It is executive. Why should it come before division bench? Examine it.
I will examine.
We were under the impression that the 7C gives some rule making power on the with some rule making power in the state government. It is not there. 7C just refers to granting it, and in reference to that, some scheme has been framed. That scheme has been notified, and therefore it will not become statutory in character.
I will examine, my lord.
Where is the question of tomorrow? Come tomorrow. Necessary.
Tomorrow.
There is nothing, mister. Every petition cannot come before division bench.
Since I have challenged the virus of it,
virus. You can challenge virus of anything, but only if you challenge virus of statutory provision, that should come before the division bench. We are of the view that this is not statutory provision, statutory in character. That is not binding on everyone. It's a notification issued by the government, not in exercise of any rule-making power. If we are not clear, despite saying all these things, then I do not have the capacity to convince you more.
Then, my lord, may remit.
No, Monday, tomorrow, Monday. Monday.
Item 56.
Fifty-six, my lord. In item number 56, there are 3 writ appeals. Combinedly to be had. In one writ appeal, your lordship has directed me to file an affidavit, whether this registration has been completed. I have filed an affidavit. Today he has filed, and the other side has filed a response affidavit to that, in which there are many factual allegations. So I have to file a reply to that affidavit because that is essential. So I pray for 1 week time or 2 weeks
Your
time.
Lordship kindly appreciate, there is a direction from the apex court for early disposal of this case. State has come up against the order of the Honorable Single Judge, suppressing certain fact. He has obtained an order of interim order to withhold my document, though it is completed, my lord. And then I approached the Honorable Apex Court, where my Apex Court said that you pursue your remedy there first. For early disposal, there is a direction. And last week, I filed this affidavit on 13. On 13 itself, I said I gave all the documents which establishes that the registration is completed in all respects since long. Before the order is
How
passed.
many months have passed after filing of your affidavit?
No, my lord. There is,
Actually, the day
in
before
fact, my lord, there is a clarification in nature only because he said there is no complete registration.
Maybe because we have brought on record certain facts.
I've only brought to my lord's notice
Let
because
him go through that. 14th was holiday. We are today is 15th.
Your Lordship,
So let it come on 22nd.
22nd, yes.
On 22nd.
I am the appellant.
He was not a party there in the court. The first time he came and challenging.
My lord, I am the judge.
It will come on 22nd. You be here. And if you have any time constraint, you please tell the court. The court may take up your matter on priority basis. But today we are adjourning it. All right. Any objection to it?
My lord, I pray, my lord, can you take the case on the 23rd?
23rd. All right. 23rd.
My lord, I am the
Happy?
appellant. I appear in person.
All right. All right. Yes. One matter was fixed as the first case. And we were of the view that we can finish the list and then take up that matter.
My lord, interim order may kindly be extended.
All right.
Interim order, my lord. The item 14.
All right. Anything else?
There is an interim order, it may kindly be.
It will continue. Happy?
Okay.
What is your name? क्या नाम है आपका?
Jagannath Basti hai.
Jagannath.
I appeared in person.
So that matter was fixed as the first case, and we are taking up that matter because
Sir, that is a very small matter, if your lordship will permit. In one case, your lordship has directed me to file the counter affidavit. I have filed it today.
Item number 70, your lordship.
I have sought copy to my laundry. Let it be adjourned to some other day. She may file rejoinder or
Yes.
that is only the prayer. That is item 70.
then someone may say something 71.
No.
Let it come tomorrow, madam. Huh?
Your lordship, just now they have filed the counter. And
Let the matter come tomorrow. Also,
as
be here tomorrow.
lordship, we'll file regent.
Item 61, my lord.
60.
As per my lordship direction, they have filed the counter affidavit. It may come next week, man.
Let it come tomorrow. We would like to see all of you again tomorrow.
Interim order may continue in 7.
It will come tomorrow.
Oh,
madam.
bless you.
Because we were making an attempt to exhaust the list and come to the first case. But somehow or the other, the first case could not be taken, and I know that case is going to take some time. Therefore,
That is why we mentioned before your lordship, because that case is very small, only adjourned.
all the cases will come tomorrow. All the today's cases will come tomorrow.
Obliged, obliged.
No other cases will be taken up.
That we can't say. It all depends on Mr. Acharya, how much.
He says that he will take.
No, I have not said anything.
That depends. A lawyer cannot.
That's correct.
It all depends.
That's right. But mine item is last one.
Here is last one. Then you ask someone, your junior, to be here.
I am here. What would I do? Go?
You wanted to go.
No, what would I do? It is better to be here.
No, if you want to go, you may go. Please ask your junior to be here and make a mention if the matter is called out. So there is no chance. And
I have a formal amendment, Lord. That petition I have filed. Say that formal amendment is that the cancellation of the tender came to my knowledge after the filing of
We will see later when the matter is taken up or tomorrow.
tomorrow.
Tomorrow. Yes.
Item number 1, sir.
Yes.
Madam, may please, Lords.
So the before you begin,
Madam.
it is our prima facie view that force majeure doctrine will not apply.
No, that would not apply. I concede. I concede. I concede. That this right, my lord, is basically basically flows from the statute. It says statutory right to operate the query for a fixed period, which is statutorily determined. Earlier it was 20 years, Section 8. Then another 20 years, they extended by an amendment. And the third, Section 8 of the old MMDR Act, old Act, I got the lease in 1974. Section 8 of the Act, your Lordship may kindly peruse. MMDR Act. MMDR Act.
This one?
My lord, that is the new book. Prior to 2015, 2014.
Do you have that book?
It may not be there because new books have come. I'm reading it. I was here. Remember here. That is not in dispute. I don't think the lunch.
Even the things which are not in dispute are required to be known by the court. Yes.
2000, prior to 2015 amendment, the period was 20 years, then 20 years, The first renewal, that was for a total period of 40 years. So by virtue of the 2015 amendment, Act 10 of 2015, by virtue of subsection 3 of Section 8 capital A, the period has been extended up to 50 years from the date of the lege. That is not in dispute. Your Lordship may verify. I'm reading Section 8, the old unamended section.
That book is coming, Mr. Acharya.
That book, yes.
Do you have one spare copy? Do you have a book? I don't. Old book?
I don't have.
You will also have to have.
I have new books.
How can you argue on?
Not that one.
This is an old book, new books. Have you given the list of books?
List of books I have.
On which you will be placing reliance other than this?
No, no other book.
You are not relying on any other.
No other book is required. Only MMDR Act.
So when were you granted environment clearance?
Environmental clearance I got in 2012. Prior to that, I had in 2009, Milord, that expired. That I was granted in 74. Three things are necessary to operate the ledge query. Milord, first is consent to operate. Second is environmental clearance. The third is mining plan. That is to be done by the IBM, Bureau of Mines. Milord, this 2009, they issued a notice that the statutory compliance of environmental clearance and the consent to operate is not there. I obtained it in 2012, submitted it to the controlling authority, who is the deputy director of mines of the local area, lease area. He recommends to the director of mines within a month. Let the director recommends to the government in 2012, the same month. But the government Milord takes a decision after 3 years and 10 months, thereby depriving me the right to operate the query for the entire statutory period of 5 years. That is the solitary question, Milord.
From which period? From which date?
From 2012, since I obtained the statutory clearances to resume the operation, till the date of passing of the final order in November 2015, Milord. They didn't, Milord, permit me to resume the operation, notwithstanding the fact that I had obtained all statutory clearances to operate the ledge. So this arbitrary, Milord, there has to be a reasonable period to take a decision in the government level. They can sit on the matter for long 3 years and 10 months and finally come out with an order that you are permitted to resume. This renewal and resumption, Milord, are two different connotations. Renewal, Milord, if they do not pass after the application has been made before 1 year of the expiry, there is a deemed renewal. Initially, it was 20 years. Then it was, Milord, for 40 years, extended for 40 years. Now, by virtue of operation of law, by the insertion of Section 8 capital A in 2015 amendment, the period is 50 years. Milord, admittedly, it is valid till 28th of February 2024. That the state doesn't dispute. My solitary grievance before your lordship is that I am entitled to operate for the whole period of 50 years. Subject, of course, the period from 2009 to 12, I don't have any claim because I did not fulfill the statutory requirement.
But once I fulfill and obtain the statutory clearances, the director, who is the authority to Milord to recommend to the government, he recommends in 2012 March, Milord, 2012 January, and the government Milord finally passes the order in November 2015. That is after 3 years and 10 months, thereby Milord depriving me of exercising the valuable statutory right. That's the sole question. If there is an arbitrary curtailment of the period of the statutory period, Milord, for which I am entitled to carry on the operation, that is the sole question. Milord, there is no claim, admittedly, for the period from 2009 to 2012. Milord, I have prepared a short date chart.
No, when was the mining lease granted?
In 74, Milord.
In 74?
74, that was for 20 years. Then from 94 until 2014, Milord, it was extended for another.
94 till?
1904 till 2014, Milord.
20 years.
20 years. Then from 2014, Milord, when the lease was operating, this amendment came into force. The total period became 50 years. Section 50, Milord. All leases, Milord, all over the country, they got the protection up to 50 years. Milord, subsection 3 of section 8 capital A, by Act 10 of 2015, Milord, they extended. That is a deemed extension until 50 years. Milord, 20th February 2024 is my last date. Period of 50 years would expire on that date. That is that they don't dispute. It has been renewed by virtue of the operation of law, subsection 3 of section 88. So they say that this period, I'll come to that. What is their answer in the counter affidavit? They say that government, with all promptitude, took the decision. There has been no lapses. 3 years and 10 months, if an authority sits over it. And Milord, what they did, in fact, they confused with resumption and renewal. There is no question of.
No, but when was that granted? After 3 years in 2015?
November 15, Milord.
So did you raise any grievance then when it was granted?
Yes, Milord, I raised it. I went before the divisional authority also. Milord, my place, I'll come to that
what
one by
happened
one.
then?
So divisional authority directed that the government is confusing between renewal and resumption. When the lease is subsisting until 2014, they passed the order, Milord, that you immediately permit them to resume. Milord, that also they took 1 year and 10 months.
No, they may be taking 1 year and 10 months or whatever. They take 3 years and so many months.
Yes.
But when the period was being extended in your case, did you raise a plea at any stage that, see, you were not permitted to do mining work for this period of more than 3 years?
3 years and 10 months.
So did you
Yes,
ever?
Milord, I raised. Also in 2023, Milord, they rejected it on the ground that it doesn't come within the purview of the force measure. So therefore, we can't give that period to you. That is the impugned order, Milord. The final order which was passed in 2023, Milord, I have
Before 23?
Before
23?
No, before 23, Milord, they didn't pass any order. Before 23, Milord, there are so many communications.
Therefore, when they were granting you permission to continue with the mining,
my lord,
did they were under the impression, everyone was under the impression that your period will expire sometimes in 2024. According to you, you should expire in 2028. This is your contention.
That's correct.
It should expire sometimes in 2028 or by the end of 2027. So, what was the first point of time when you raised your claim that you are entitled to continue up to that period, not up to 24?
No, Milord, that I have raised before them. The final letter I have annexed when I wrote to them.
No, for the first time, we are for certain reason we are putting.
Milord, I have not annexed, Milord. The final last letter I have annexed.
No, not last letter. For the first time, you might have agreed to whatever decision was taken by the state government, by the competent authority.
No, my lord, there is no question of any agreement because why I say, my lord, let me just explain one way. Your lordship is correct that that is also at what material point of time I raised it.
For the first time.
No, that's correct. So, my lord, what I objective, let me one by one, let me formulate. My lord, in 2009, the lease was in subsistence. Also in 2014, until 2014, it was in subsistence. February 2014. My lord, in 2009, they write a letter, a general letter to address to many lessons like me, so that you do not fulfill, these are the requirements which are deficient. So you kindly obtain those documents, clearances. I applied to the concerned authorities. Let the environmental that has to come from the government of India after the hearing, a public hearing and all that. So this consent to operate is to be issued by the Pollution Control Board. And the mining plan is for the whole period. So it was there. So these three things I obtained and submitted to the Deputy Director of Mines.
No, all right. Again, we are putting another question.
My lord.
Is there any provision
My lord.
that if for any reason
My lord.
the lessee is not permitted to, or because of the inaction of any authority, he cannot execute the work of mining, then that period should be added beyond the final period of total period of.
That language is very, that's the tricky thing your lordship is putting. I am also, my lord, asking that question to me several times. Your lordship may kindly have a glance. The language employed in the statute itself. That is why that gives me the benefit. Subsection 3, my lord, substituted by
Subsection 3
of section 8 capital A. Your lordship will get it in the new book. Because prior to 2015, my lord, the law was 8 capital A was inserted.
You will be placing reliance on both the provisions.
Both the provisions. No, finally, my lord, this subsection 3 of the amended section will prevail. That your lordship may kindly, because that is the last amendment which was made in the statute.
Yes.
Lord, I am concerned with subsection 3, but before that, your lordship may kindly also read. This particular word has been employed in both the subsections. On and from the date of commencement of the Mines and Minerals Development and Regulation Amendment Act 2015, all mining leases shall be granted. Let this last 5 words for the period of 50 years. Let this for the period of 50 years is important. So let this is statutorily fixed. So any arbitrarily curtailment of that, abridgment of that period, Milord, is certainly not sanctioned by the law. So, no, Milord, your lordship may kindly, I am explaining.
Very difficult, Mr. Acharya. The language is very clear. On and from the date of commencement of the mines and mineral, all mining leases shall be granted for a period of 50 years.
For a period of 50 years.
Yes.
Milord, I am entitled to have that full 50 years period. Unless, Milord, the default is attributable to me. Suppose, Milord, I am not claiming any benefit for the period for which I didn't possess the requirements.
Right. We have understood that.
So I am concerned with subsection 3, Milord.
We have understood that.
Milord, subsection 3. All mining leases granted before the commencement of the so-and-so act, I am covered under this, because it's a grant prior to the commencement of the Amendment Act, shall be deemed to have been granted. By virtue of this fiction deeming provision, they grant it for a period of 50 years. Notwithstanding this 2020 and first renewal, second renewal, Lord, I am covered by this subsection 3. So from 74 until 2024, under ordinary circumstances, Milord, had I been allowed to fully operate, save and except the period for which I have lapsed. So then I am protected for the whole statutory period. So, my lord, what I objectively submit to your lordship's
So was
consent.
there any provision
Yes.
in the lease deed itself that in case you are not allowed to do the mining work for a particular period, then the period shall be extended beyond the period of lease?
Lord, there is only that force measure clause, your lordship is right.
measure.
That is there. So apart from that, my lord, if your lordship would look at, there is no clear provision. My lord, let me be very fair with you.
Yes, yes, that is the benefit
Yes.
of having a senior responsible counsel
That's correct.
arguing a case.
So Form K read with this Rule 12FF, Lord, that is the provision which say that in the event of this, which is, my lord, your lordship may kindly again also read that force measure clause. Lord, Form K, which is in parameteria with the present Rule 12FF of the mineral concession rules.
Page?
2000, my lord, page 2016 rules. Mineral, my lord, this old 1960 rule was also, my lord, replaced by this 2016 rule.
Which page?
Minerals, my lord, your page, if your lordship is holding this professional publication,
Yes.
then that would be at page 394. My lord, the similar clause is contained in the Form K in paragraph 4 of the agreement that forms a part of the agreement. This
page number
394.
394, yes.
Holding this book, then that
Yes,
would
yes.
be 394.
Which rule?
This, my lord, clause FF of Rule 12, my lord. It's a very lengthy rule, which begins from page. Lord,
Yes.
it begins from page 388, terms and conditions of a mining lease.
Yes.
Lord, I am placing this clause FF. Sub-rule 1,
Yes.
then clause double F, small double f.
Yes.
Failure on the part of the lessee to fulfill any of the terms and conditions of the act and rules made thereunder, or under the mining glitch, shall not give the central government or the state government any claim against the lessee, or be deemed to be a breach of the lease, insofar as such failure is considered by the relevant government to arise from force majeure. In the event of any delay by the lessee to fulfill any of the terms and conditions of the act and the rules made thereunder, and under the mining glitch, on account of a force majeure event, the period of such delays shall be added to the period fixed by these rules or the mining glitch. So admittedly, my lord, the statute authorizes for adding that period. It is there. Lord, in this clause, Lord, this is important. In this clause, the expression force, they qualify force majeure though, means an act of curd, war, insurrection, riot, civil commotion, strike, earthquake, tide, etc., etc. And, my lord, the last two sentences. And any other happening which the lessee could not reasonably prevent or control. Lord, this is not within my control. The state's apathy or inaction for a long 3 years and 10 months period is not certainly attributable to the lessee, for which he should be made to suffer. So that period he is entitled to be compensated if your lordship put strictly by applying the rule of construction. Even though, my lord, the statute specifically doesn't permit so, but it says that the event of a force majeure situation, the lessee is entitled to the benefit of the lapse period. So for your, I am reading without laying emphasis, and any other happening which the lessee could not reasonably prevent or control, my lord. It is certainly not within my control. The state's promptitude to take an action or a decision, my lord, on the recommendation of both the controlling authorities, the nodal authority, Director of Mines and the Deputy Director of Mines. They write in January 2012, they sit over it quietly and finally come out with an order in November 2015, which is almost 4 years, 3 years and 10 months. It's a substantial period. They collect the royalty, they collect the dead rent, everything. The states gets the revenue for that. Not that I have been exempted for that period of making the payment, even including the period for which I didn't possess the required statutory clearances. There is no agreement on that. They say that because it is pending with the government, but their answer is very evasive in the counter also. That I'll place my pleading and their reply. So there is no answer to this. Why they were sitting over the matter for such a considerable length of time, period of time, there is absolutely no explanation. So the lessee should not be made to suffer for that. The statute recognizes, my lord, even authorizes to government to extend that period. Not that it's not German or strange.
We have understood. This part of your submission, we have
That's
understood.
Sure. Number two, my lord, they have
So your submission is
yes
that the force measure
my lord,
has been defined under the rules.
My lord.
So the general interpretation of force measure
Right.
may not apply in this case because of a particular definition given in the under the rules itself.
Absolutely.
This is your submission.
Absolutely. Absolutely.
And you are relying on that part of any other happening which is not within the control of the lessee. This is your submission. This part we have understood.
Absolutely correct.
This submission we have.
So, Lord, the second objection which they have taken to my petition, that I should have gone in revision as per section 30, my lord, I am answering that. Your lordship may kindly look at section 30. Lord, it's a lease for two minerals, dolomite and limestone. But earlier, both these minerals were under the major mineral. But after 2015, my lord, this when this massive amendment was carried out in the law, this dolomite is no more a major mineral. It's a minor mineral. So in case of a minor mineral, my lord, no revision lies. So, my lord, section 30, your lordship may kindly turn to. So, my lord,
So you will be mining only dolomite.
Dolomite.
And
So
the other mineral?
So that is, my lord, limestone.
Limestone.
Limestone, my lord, there is no limestone in that area. Practically, I am doing dolomite, which is a minor mineral now. Even, my lord, your lordship knows the recent judgment that Godrej Lee, apart from Whirlpool Corporation and other Madhya Pradesh Bar Association case, there is a recent judgment, fortunately I got it in the morning, that this existence of a revisional power doesn't oust your lordship's jurisdiction.
No, that you know you are not required to refer to any decision.
That's correct. That's a settled law, my lord. So, my lord, there is absolutely a clear law.
No, but again, the question is that we will see. The question is whether the revisional jurisdiction is revisional forum is there or not.
No, revisional forum is central government, my lord, but minor mineral will not lie.
Yes. So therefore, you can take this plea specifically that revisional.
That I have argued. Your lordship may kindly look at section 30, my lord. 30.
33.
30, my lord. 30. Let the last order of this bench also, coordinate bench, that also clearly says, and is counsel for the state was directed to obtain instruction on this. That was my submission. The last order, my lord, transfers. It was a very exhaustive order. The central government may, of its own motion or on an application made within the prescribed time by an agreed party, revise any order made by the state government or other authority in exercise of the powers conferred on it by or under this act with respect to any mineral other than a minor mineral.
Yes.
Revise
Yes, Mr.
that this 30 so excludes the power of revision. So far the minor
That is clear.
bill. And Dolomite has been notified, my lord. In 2015, all those massive amendments they took place, my lord, in the MMDR Act. They wanted to introduce this auction theory, no mechanical renewal and all that. So that era is gone. So therefore, that is the two hold submissions.
Minor mineral comes under which subject?
That's a
State.
Union list. It's in the union list.
No.
So minor mineral may not be.
be,
It is
and
the-
therefore
yes.
that exclusion is there.
Yes, that's correct. Minor, I'm sorry, I misheard.
This is what
That's correct, Milord. That's correct.
I think.
No, your
Again,
lordship
I
is
may be-
correct, Milord. That's the appropriate.
That
term.
must be the reason.
That's correct.
And therefore, minor minerals are governed by the
That's
state acts.
That's correct. No,
Yes.
state doesn't have any act, Milord. They frame the rule under this.
Rules, yes.
Yes. Under this MMDR Act
Right.
that authorizes
Right.
the appropriate government
Right.
to make the rule. Accordingly, there was a 2004 rule. Now that has been replaced by 2016 rule. Orissa minor mineral concession rules. That rule making power is there in the act itself. Milord.
Yes.
Section directly. The rule making. Yes. Let section 15 authorizes the government. The
Section?
state government 15 million. Power of state government in respect of minor minerals. So the state government may by notification in the official gazette make rules for regulating the grant of quarry leases, mining leases or other mineral concessions in respect of minor minerals and for purposes connected therewith. Section 15 million. What is like this? States head over the matter.
Entry 53 and 54 of list 1
My lord. Dolomite.
deals with, no, list 1 of the union list. The Constitution.
Milord, 7 schedule that's a union list, Milord. That is in the union list.
Union list.
Yes.
And then come to entry 23.
23, Milord. Constitution.
Of state list.
Minor.
So minor minerals, the parliament has given, the state has to make central government was not even.
These are the Milord twofold submissions. If your lordship would permit me, I'll place 2-3 latest only. Milord, page 93 also, this rule 12(1) FF which I read out, Milord, that is also embodied in the agreement itself, lease agreement. At page 93, your lordship would find the same language that has been quoted, which forms a part of the agreement too. And the lessee could not reasonably prevent or control and any other happening. Page 93, Milord.
So your entire case is made on that expression.
That expression. Milord, that is the only silver lining which, Milord, goes in my favor. So that is, if it is, Milord, by rules of construction, it is to be interpreted. Not that, Milord, the statute doesn't recognize any additional period. It is.
Have you examined whether such expression has ever been construed?
No, it has not been construed. This expression has not been construed. I have made the research. So far, my limited resources are concerned. I have.
These days, everyone's resources in terms of, for the purpose of search is unlimited.
There are very limited case laws on this. If your lordship would find hardly 10-12 judgments in all. So.
All right. Yes. Then.
So your lordship may kindly turn to these 3-4 annexures which are important. So I was, Lord, page 93, I pointed out this, that is akin to which was earlier Form K. So that's a part of the agreement, page 93.
Page 93.
Page 93, Milord.
Just
the last, Milord, in this clause, the expression so and so, and any other happening which the lessee could not reasonably prevent. The last, Milord, 5-6 lines at page 93 of the brief. Last 6-7 lines, last paragraph rather, and any other happening, last 3 lines. It is written on the deputy director. 5, no 5. 8 am the
Yes.
Manner. Lord, 3-4 annexures your lordship may kindly peruse. Page 136, Milord.
What did you do when they were delaying your matter? What did you do?
No, it was in subsistence, Milord. So it was a running glitch. It was, Milord, a running glitch. Time had not expired. It was until 2024.
No, time had not expired, but you were not allowed to do the mining work because
the period for which I was not allowed, Milord, that fault is attributable to me. 9 to 12.
Yes,
that is why I am
after 12,
pressing 2-3 annexures.
After 12,
My lord.
because of the failure on the part of the state government, state authorities, you could not do your mining work
My lord.
because of their failure.
My lord.
So what did you do?
I went to the revisional authority, my lord, because at that time, this minor mineral section 30 was not there. It came into 2015. That was included.
Yes.
I went to the central government. But that order is there. I have annexed.
That we have seen.
Yes.
Yes.
Your lordship may kindly
Let us
turn
see that again.
Not only 3-4. Let me, if your lordship would permit me.
Please.
Page
Please
one.
argue in your
Yes,
your
my lord, one. No, your lordship is putting pertinent questions. It is my duty to answer those questions first. Then
Thank you.
I am trying to answer. Let annexure 6 I wrote. 2009 they stopped. After, my lord, I obtained those clearances. I wrote to the deputy director, who is the nodal authority. Lord, I write it that I would like to bring to your kind attention that our mining operation has been suspended since 10th November 2009 for want of statutory documents, environmental clearance and consent to operate, as ordered in your circular dated so and so of November 2009. Now the same have been obtained and as asked by your good self, and details is as follow, and copies of the same is enclosed herewith for your needful. We request your good self to kindly allow us to resume our mining operation with immediate effect as per the quantity of minerals permitted in the environmental clearance and consent to operate is granted. Lord, the next annexure at page 137, the deputy director, my lord, immediately writes. No, my lord, annexure, I'm sorry, 8, my lord. Annexure 7, then 8. Let the deputy director, by his letter dated 16th January 12, as soon as he Lord receives these clearances from me, at page 138, your lordship would find, he writes to the director, his immediate superior authority, my lord, suspension of mining operation, so on the ground of non-maintenance of statutory, resumption of mining activity thereof. But he writes, with reference to the above cited subject, I am to apprise for kind perusal that mining operation in respect of Dharuara, Kukuda, limestone and dolomite mine of Jalan has been suspended in this office letter number so and so on the ground of non-maintenance of environmental clearance and valid consent to operate. The lessee has obtained all statutory clearances in the meantime in respect of their above mines and submitted copies of same to the office on 9/1/2012 with request to allow for resumption of mining operation. The said mine does not include any forest land. The lessee had previously applied to government in their letter number so and so with reasons for discontinuance of mining activity as per clause, as per rule 28(2) and required application fee of 200 only by so and so as per rule 28(3) of the mineral concession rules to save the lease from lapsing. But if it is applied before the period, statutory period under rule 28, it will not lapse until, my lord, an order is passed. There is a judgment to that effect, and that is also in the rule itself. So as in the meantime, a continuous period of 2 years of discontinuance of the mining activity has elapsed for genuine reasons beyond control of the lessee, and all these statutory, my lord, this which I was emphasizing, beyond the control of the lessee, which is not within his control, lessee, and all the statutory clearances are now maintained in respect of the above points. Government may please be moved to pass an order regarding extension of the lease under rule 28 and allow the lessee to resume the mining operation. Then the director's letter to the government at page 139 annexure 8. From the director mines to the additional secretary to government. This is a very exhaustive order which justifies this puts the whole hardship. In inviting a reference to the above noted subject, I am to say that Sri Jalan held a mining lease for so and so and dolomite over an area of so and so. The lessee surrendered an area of 533 million. This total area granted to me was 573. I surrendered because that was not virtually not any mining is, ore was there. So I surrendered 533 out of total lease of 573. It is only in respect of 39 hectares, very small area. So the ground to hectares within the leasehold area, attributing the ground to barrenness, which has been accepted by the government on 30/10/89 and retained an area of 39 hectares. The original ML period expired on 22/1994. The lessee Jalan has applied for renewal of the mining lease on 16/2/93 over the entire retained area of 39 hectares within the stipulated period. That is 1 year before expiry of the original lease term as per Rule 24A, capital A of Sub-Rule 1 of MCR Rule so and so 1960. The said renewal application is pending for disposal at government level, and the term of the lease is deemed to have been extended till disposal of the RML application in accordance with provision of Rule 24A6 of the MC rules. The mining operation was being carried out in the deemed extended period. The Deputy Director of Mines suspended the mining operation in respect of the aforesaid area by letter dated 7/11/2009 on the ground of non-availability of environmental clearance from Ministry of Environment and Forest Government of India and valid consent to operate from the State Pollution Control Board. The lessee as such discontinued mining operation for more than 2 years, which attract provisions of Section 4A4 of MMDR Act, read with Rule 28(1)C Rules 1960. Discontinuation of mining activity of the lease for a period of 2 years has elapsed for genuine reasons beyond the control of the lessee, as reported by the DDM Raulkela by his letter dated the previous annexure which I read out. The lessee by his letter dated 23/3/11 has applied to save the mining lease from lapsing in accordance with Rule 28(2) of the rules, along with requisite application fee prescribed under Rule 28(3) of the MC rules within the stipulated period to government under intimation to this directorate. As reported by the Deputy Director of Mines, the lessee in the meantime has obtained all the statutory clearances in respect of the above said mines, valid mining scheme for the period 2009 to 13, approved by IBM, by their letters one so, environmental clearance for production of limestone and dolomite, Odisha, and consent order granted by the State Pollution Control Board under Section 25(26) of the so-and-so Air Prevention Act, which is valid up to so-and-so. Copies of all statutory clearances as received from DDM Raulkela are sent herewith. The said mine does not include any forest land. The Deputy Director of Mines has also reported that the discontinuance of mining operation was beyond control of the lessee, and the lessee since has obtained all the statutory clearances for which the government may consider to allow the SC to resume the mining operation. But this is very important. But there is a distinction between resumption of operation which was suspended and the renewal of the lease. They are the two different terminology under the Act. So that is exactly what the Government of India, the Revisional Authority, pointed out in its 2014 order, January order. If your lordship would turn to no action for long 3 years and 10 months, almost 4 years. Finally, they issued me notice, while this application recommendation was made to the director that you come forward for hearing. There is no question of any hearing. That is with regard to the renewal of the lease, for which the application was pending for renewal. And there is a provision for deemed renewal until the final order is passed by the government by giving reasons and giving. So it has no connection. They confused with resumption and the renewal and kept on issuing the notices after notices, for which, my lord, I was constrained to approach the Revisional Authority. Then, as per Section 30 of the Act, that the Revisional Authority's order is very clear. Your lordship may kindly turn to Annexure 4, my lord. Sorry, Annexure 13 at page 154, my lord. It's a lengthy order. Milord, para 11, I will place, Milord, very briefly, 157 page. The revisionist, Milord, only 11 is important, pertinent, I'm sorry. So, your lordship, I'm just placing this much. Furnish the EC issued by the State Environment Impact Assessment Authority, Odisha, and the consent order of the State Pollution Control Board to the DDM Raulkela on 9/1/2012 and requested him to allow resumption of mining operation in the lease area. The DDM suggested to the DM on DM means Director Mines, DDM is Deputy Director Mines. On 16/1/2012 to obtain state government orders to allow resumption of mining operation, and the DM in turn proposed to the state government on 19th March 2012 to allow the resumption of mining. Everywhere they are using the word resumption for operation pending grant of RML. RML means this renewal mining lease, renewal of RML. So though grant of RML and grant of permission for resumption of mining operation are separate issues. This is the revisional authority's finding. Issues, the state government, by clubbing both the issues together, held a personal hearing on 16/5/2012 and asked the revisionists to submit MDCC, that is Mining Dues Clearance Certificate, CC, and indicated the grant order for the RML and permission or resumption of mining operation could be issued simultaneously. There is no question, there is no link between this RML and the resumption. My lease was subsisting till 2014 by virtue of law and until disposal of the application, which was made in conformity with the rule. So, without permitting me to resume the operation, they went on, sitting over it. So, after the intervention of the divisional authority, your Lordship may kindly come to the next page, The state government in their para-wise comments, para 14, have not disputed the question of facts. The state government stand is that the demand raised for the basis of report submitted by the accountant general is a genuine. It has no correlation with this. So finally, in para 19, in view of the observation above, the state government is directed to allow resumption of the mining operation till the expiry of the current lease period, which was up to 20th of 2015. Now, by virtue of subsection 3 of the amended provision, it is still 20th February 2024. So therefore, finally also this order came to be passed on in January 2015, 14. January 2000, your Lordship may kindly mark at the silence, pink slide silence of the government.
Yes.
January, they passed the order also, after 1 year and 9 months on 8/10/2015. There they, killed total period 3 years and 10 months. Here also, after the revisional authorities order, which now they very evasively suggest or in the counter affidavit that I should again go to the revisional authority, so that the whole period, your Lordship, Annexure 14, at page 160, they passed this order. That is also in pursuance of the direction of January 2014, 1 year, 9 months they took to pass this order. So this is the apathy and arbitrariness of the state government. So for which, I am to be compensated. This the in a nutshell, this is the case.
No, but again, we are putting the same question.
My lord.
That after 2014, when you resumed your work, 15 or whenever, did you raise your claim before any authority, before coming to this court or recently when raised your grievances?
Let the last representation, I have.
First, we are interested
first I have not annexed, Here
you have, even if you have not annexed, you can take a plea at least for us to consider.
I have, your Lordship may kindly look at it. It's a very...
Otherwise, we may presume that you accepted what was granted to you and they were not required to extend the period of lease on that grounds.
This annexure 16, is a very exhaustive application which I made to the state government that begins at page 163 of the brief. That is well within the period of lease, 4th of July 2022,
Page?
Page 163,
162?
163, 163 at annexure 16. That is much before the expiry of the lease, which is has not expired.
Soon after. See, you were entitled to start your mining work from 2012 itself.
2012 nahi, 2015 Milord.
2012, when your everything was clear. You were
Everything was
entitled
clear.
to
My lord,
begin.
my lord.
In 2013, in 2014, did you tell them that, see, you are, or even 2014, when you finally resumed, did you tell the government that now, in view of these facts, you are required to extend that period? That period should, this period should be added to the total lease period.
No, that, my lord, I have not. I requested them for resumption. I didn't know that they would be, my lord, taking such a long period of time.
Therefore, when did you raise this claim?
My lord, this claim, last claim which I have annexed is of.
Last again, Mr. Acharya. Last is last. First.
So, my lord, there was no occasion in between. Your lordship, in 2016 they executed the supplementary agreement.
So did you presume when you started in 2015,
my lord,
did you presume that because of that force majeure clause, you will continue till 2028?
So, my lord, certain things are not, your lordship knows that law is very, even it is taking time for us to understand law and interpret.
Yes, everyone.
That's correct. So, people become wiser by efflux of time. Maybe.
No, but these are very simple thing. Even a rickshawala can understand.
Yes.
This, that if I have a right, I must stake the claim.
That's correct. So that claim finally, my lord, has been rejected by their order, which is impugned. So this claim, my lord, I have raised at page 163 of July 2022. That is the last. I have to take further instruction whether it is there or not prior to that, because we always see the last order, whether last representation they made in.
That's all.
I think that's all. Not so.
Let me please the lordship. Two questions fell from your lordship. One is, did you ever complain? And the second was, my lord, is there any provision for extension of mining lease? Let me answer the first question first. Your lordship may kindly turn to my counter affidavit, to my affidavit dated. There's an affidavit dated 8. There is an affidavit filed by the petitioner 18th of January 2024. 18th of January 2024.
Yes.
And if my lords are kindly pleased with us to turn to internal page 10.
Of what?
Of that affidavit filed by the petitioner. It is dated 18th of January 2024. And it says additional affidavit filed on behalf of the petition.
Yeah.
And if my lords kindly sees minutes, at page 9 of that affidavit, there is a supplementary lease deed. My lords have it.
Just a minute. Do you have the running page? 222. Yes, we are there.
Yes. My lords have it, my lords.
Yes.
Page, it is annexure B, page 9. Now, this is a supplementary lease deed dated 30th of March 2016. My lords have it.
Yes.
Now, kindly turn to my lord, internal page 12.
Yes.
Whereas the lessees have executed a mining lease deed on 21/2/1974 in accordance with the Mineral Concessions Rule 1960 in respect of the land described in part 1 of the schedule of the said lease, limestone and dolomite ore over an area of so-and-so in village so-and-so, so-and-so, so-and-so. Next paragraph, my lord. And whereas the said lease, whereas period of the said lease was valid from 1974 to 2294, that is 20 years. My lordships have it, my lord. In the next paragraph, and whereas after expiry of the validity period of the lease deed, the lessee continued to conduct mining operations in the said lease under the deemed extension provision of Section 8 of the MMDR Act 57 read with so and so with permission of the first part till 11/2/2015, passed in Miss Case number so and so so and so. Kindly turn over the page, my lord. And whereas the MMDR Act has been amended with effect from 12/1/2015 and Section 80 has been inserted in the said Act, providing for extension of validity period of the lease granted in the past under the provisions of the said Act, subject to fulfillment of conditions provided therein. And whereas the lessee has surrendered an area of so and so and government has accepted it on 30/10/80, the government of Orissa. Now, this line is important. The government of Orissa has decided to extend the validity of the lease period up to 20th of February 2024 over an area of so and so. So there he did not say in 2016 that I'm entitled to throw more in the past. That's my first submission to your lordship. So therefore, here is a statutory lease deed. He has accepted in 2016 that I will work till 2024 and not beyond. Now, why did he accept this? Would your lordships look at the MMDR Act, Section 8A, capital 3. My lords have that new book, my lord. 8A is at page 14 of this 8A, 8 capital A 3 of the MMDR Act, subsection 3. If your lordships are holding this book, then it will be at page 14.
Yes. Yes.
My lord, prior to this 2015 amendment, as Mr. Acharya rightly said, original lease period was 20, renewal for 20, and then many further renewals. There was no cap. In 2015, they said that we will amend this act now. Lease will be for one time 50 years, and after that it will be auctioned. And this all leases after 2015 are always put to auction. But some lessees who had not got the benefit of 50 years now were made under 8A3. They were also brought at par with the new lessees. So therefore, my lords, 8A3 said, let me read 8A3. All mining leases granted before the commencement of the MMDR Act 2015 shall be deemed to have been granted for 50 years. May I read it again? All mining leases granted before the commencement of the mines and minerals development. I'm sorry.
8 subsection 3.
8 capital A subsection 3.
Oh, yes.
I'm sorry. I'm so sorry.
Yes.
8 capital A subsection 3.
Yes.
All mining leases granted before the commencement of the Mines and Minerals Development Regulation Amendment Act 2015 shall be deemed to have been granted for a period of 50 years. The supplementary lease deed your lordship just saw took it to the period of 50 years, fulfilling the mandate of 8A3. Now look at the next subsection, very important. On the expiry of the lease period, namely expiry of 8A3, the lease shall be put up for auction as per the procedure prescribed in this act. So therefore, my lords, no extension is contemplated under the provisions of the act as it stands now, namely, after your period of 50 years is over,
yes,
the lease will be put to auction.
Yes.
And therefore, my lords, the petitioner entered into the last agreement for the balance period of 10 years without raising any dispute as to whether he was deprived of working from some period or the other. My lord, these are all statutory leases. And if your lordship sees section 19 for a minute, minutes. My lord, let us assume that he would have convinced the state that don't limit it to 10 years. Give me something more. Then what would have been the consequence? 19 of this MMDR Act, my lordships have it.
Yes.
it says prospecting licenses and mining leases to be void if in contravention of the Act. Any mineral concession granted, renewed or acquired in contraventions of the provisions of this Act or rules or orders made thereunder shall be void and have no effect. So therefore, the state could not have granted any lease beyond what is prescribed under 8A Capital 3, and the moment the period got expired, 8A4 logically would kick in to say that now this area has to be put for auction because you are at par with everybody else. That's my humble submission. That is the scheme of the Act. And 8A3 requires an agreement to be made, mining lease deed to be executed, and a mining lease deed has been executed, which your lordships have seen. So therefore, my lord, it's my humble submission, 2016, he executes a lease deed, which is valid till 24, because that is all he was entitled to under 8A3. And he could not have asked for anything else because 9 was there.
Even if he was entitled for more than what is there in the lease deed,
my lord,
he could have raised his grievance.
At that point of time, maybe he could have said, prior to 2016, when he executed the supplementary lease deed, because we are seeing his...
No, even after that.
Yes,
even after the execution of lease deed.
Correct.
Because sometimes under the, they don't have the choices.
Correct.
So they would enter into the, with objection that, see, you have granted me up to this only.
Correct.
But I am entitled for more than this because of these reasons. So therefore, we were putting this question.
I'm grateful.
Regularly.
I'm grateful. What your lordship said was that 16 you executed the lease deed. In 15, did you say I am entitled to 3 more years? In 14, did you say?
Or 17.
Never. Never. The last came in 22. 4th July 2022.
All right, we will see.
Grateful.
So?
One reply.
Yes, you are right to reply.
They can, my lord, keep silent for 4 years. Do not explain in any convincing way. That I well within, my lord, that is well within the period of my lease. I raised that issue in 2022. My lease is a subsisting lease, which is, my lord, yet to expire. 28th, my lord, hardly 3-4 days to go. So I raised that issue. They can, my lord, maintain silence for over a period of 4 years.
You
Again,
cannot.
also, my lord, I am coming to 2016.
They can maintain, you cannot.
So I can't, your lordship, but I raised it. My lord, it is not a case that I did not raise it. I might have raised, my lord, after 2-3 years. But
because you agreed to that.
No, there is no question. There I have a...
The rule of acquiescence will apply in this case.
No, there also I have a small submission. 2000, your lordship may kindly turn to. Again also, they defaulted. 2014, my lease was valid. There is a dimmed, this act came into force, amended.
No, they might have done everything before 2016. But after 2016, you enter into a lease agreement with the state government, which clearly stipulates that this lease agreement is up to the period of 20th of February 2020.
There is no, it's a statutory agreement, Mila. That is a format.
All right, their format, that may be formal, but you could have told them that why have you mentioned this date? You should have mentioned this date.
In that event, you will say this period of 50 years is a statutory period. Let me just understand that. That is for a period of 50 years, they say. I pointed out that Rule 12FF, which was earlier in Form K, the para 4, that is a part of the agreement, lease agreement. There is a thing which is not within my control, Milord, that period is to be added.
So therefore, see, there are 2 aspects.
Milord.
One, a statutory period. There cannot be any dispute about it. But there is some period which is beyond a statutory period.
My lord.
And that is the force majeure clause.
My lord.
So if in order to claim that, you were required to approach. You are required to tell. You are required to claim, represent.
Milord,
Raise
that I
anything,
did.
anywhere.
Milord, the final, Milord, if you lordship may in that event call it on Monday, let me just verify. I can find it by a supplementary affidavit. 19th, your lordship may call. If any such communication and demand, I prefer to annex the last. Let me just verify. If any communication or any demand.
All right, we are ready. We are
Monday,
ready to-
Milord, because 20th is the last date.
Yes,
Your
yes.
lordship may. 19th, let me file. If it is available on record,
Yes.
then I may submit a supplementary
All right.
affidavit.
We don't
Because
have any.
I wanted to, Milord, challenge finally the 2023 order. So the last, Milord, the basis
We'll
upon
see.
which
We'll-
they have rejected, I filed it. So if
But
this
we
is-
are very, very thankful to both of you. The way you have extended the assistance.
Milord, that's the duty, limited duty of a lawyer. Beyond that, Milord, everything comes from that side. We are just doing an humble duty, that's all.
We will see. We will hear you on 19th.
19th at 2 p.m. your lordship
At
may
2
fix,
p.m.,
so
all
that
right.
the other members will not be affected. Or 3 also at 3 p.m. so that the least will be
all right.
interested.
We can take up.
I am in his hands.
Oh, Milord. Milord, I was sincerely not trying to give him
No,
any.
if the Advocate General is under your control, then
He is an elder brother, 4 years. His younger brother is my bosom
no,
friend.
no. This is in 2024. No one can claim that because he is the elder brother, therefore you are under his control.
An elder is
Things have
always an
changed.
elder. Where is Lord, that
Yes.
is our
All right.
culture. We respect the age and the seniority. That's
I also wish. Yes. Third, Mr. So and so, and assisted by list this matter for further hearing on tomorrow.
19th. Tomorrow, Milord.
19th.
No, tomorrow, Milord. Tomorrow at 3 p.m.
Tomorrow
3
at
p.m.
tomorrow to be taken up at 3 p.m. for 3 p.m. I may be
Or
sitting
any time
in the-
after
we can
2
take up in the
2
first half.
2 p.m.
No, in the first
12
half.
o'clock, Milord, 12 o'clock.
12.
12.
Milord, I was praying
Who come-
that let the other members of the bar not be affected because. Huh?
My lord may sit single.
Oh, acha. Any time
Therefore,
convenient to your lords.
12 we will take up.
12. Milord. Deeply blessed.
Thank you.
Milord, 12. 1.
12.
12. Scrutiny there. Let 2 p.m. May I pray? No, this division bench will not.
Not a new bench.
10 what? We can take up at 10. 10:30. 10:30 we will see because this matter is has some urgency. Is to be decided. So we will take up at the first case.
Lordship, please.
How are we?